decades of experience. We request Shri S.K.Singhi to welcome Dr. Manoj Kumar. बहुत-बहुत स्वागत, बहुत-बहुत अभिनंदन. Please put your hands together as we welcome Dr. Manoj Kumar on the dais. Ladies and gentlemen, it is with great honor and delight that we invite now our chief guest to join us on the dais, Mr. R. Venkatramani, Learned Attorney General for India, as our chief guest for the day. Zordar taliyan sabhi ki or se. A senior advocate in the Supreme Court of India and currently serving as the 14th Attorney General for India. For the past 12 years, he has been appearing as Special Senior Counsel for the state of Tamil Nadu and also serves in the same capacity for the state of Andhra Pradesh. May I please request Shri S.K.Singhi ji to welcome Mr. R. Venkatramani, Learned Attorney General for India. हमारे देश में परंपरा है, कहते हैं अतिथि देवो भव. सभी अतिथियों का हमने स्वागत किया है, सत्कार किया है, जिससे हमने हजारों वर्षों से अपना परम धर्म माना है. और एक और परंपरा है जहां पर लैंप लाइटिंग के साथ, दीप प्रज्वलन के साथ ईश्वर का नाम लेकर किसी भी शुभ कार्य की हम सदा से शुरुआत करते आए हैं. मे आई प्लीज रिक्वेस्ट आवर ऑनरेबल चीफ गेस्ट एंड अदर डिग्निटरीज ऑन द डेज टू काइंडली लाइट द सेरेमोनियल लैम्प एंड बिगिन द प्रोसीडिंग्स फॉर द डे. We also request our patrons and advisors to please join us on the dais for the lamp lighting ceremony. All patron members and advisors, may I please invite you, request you to join us on the stage for the lamp lighting ceremony. We request Justice Rajesh Tandonji to please join us, former Judge Uttarakhand High Court. Justice S.L. Bhayana, former Judge Delhi High Court, to please join us on the stage. Mr. Harshvardhan Singla. Mr. M. Gandhi. Mr. Ajay Wadhwa. Mr. Himmat Mandot, National President, Terapanth Professional Forum. Mr. Ashok Babu, MLA, Puducherry. दीप प्रज्वलन ऐसा माना जाता है कि यात्रा है अज्ञान से ज्ञान की ओर और अंधकार से प्रकाश की ओर, प्राणी से परमात्मा की ओर, पदार्थ से सूक्ष्म की ओर. तो आइए सभी इस यात्रा में शामिल हो जाते हैं जो अंधकार से प्रकाश की ओर हमें लेकर चले. Let there be light in our lives and we are able to take the right decisions at the right time. The ceremonial lighting of the lamp is symbolic of a very auspicious beginning, symbolic of positive energy, and also symbolic of the blessings of the Almighty in the endeavors that we begin. Thank you very much. Requesting all our dignitaries to kindly take their places on the dais. Ladies and gentlemen, as we begin the formal proceedings for the day, first and foremost, may I please invite Founder and Managing Partner S.K.Singhi and Partners LLP, Shri S.K.Singhi ji, to kindly please welcome the august gathering today and also to set the tone for the proceedings. We welcome you, sir. जोरदार तालियों के साथ आइए अभिनंदन करते हैं श्री S.K.Singhi जी.
Jai Jinendra. Good morning to everyone. The distinguished guests on the dais, learned Attorney General Sir, Dr. Manoj Kumar, Dr. Lalit Bhasin, Dr. Satish Reddy, all the distinguished personalities, guests, and all the valued patrons on and off the dais. It is with great and immense pleasure and gratitude that I welcome you all to the official launch of Lexits, an initiative close to our heart of S.K.Singhi and Partners LLP. Today marks not just the unveiling of a transformative platform, but also a milestone in our collective journey towards justice and legal innovation. Lexits represent a bold vision, one of the informed decision-making, efficient dispute resolution, most importantly, justice accessible to all in a country where our judiciary is faced and shoulders the burden of more than 50 million pending cases. Initiative like Lexis is no longer a luxury or an option, but a necessity. This platform, through predictive analysis and portfolio-based advisories, promises to equip litigants with clarity, enabling them to make informed decisions, choices that could reduce indiscriminate court filings and resolve the disputes more efficiently. Our initiative is grounded in collaboration and expertise. It fortified by remarkable board of patrons and advisors comprising former High Court and Supreme Court judges, senior advocates and other advocates, professionals practicing at the various forums, advisors and other luminaries from academia, industry and governments. Each member brings invaluable insight and experience to ensure that Lexits remains a beacon of excellence. As we stand here in this historic Bharat Mandapam, it is fitting that we celebrate an endeavor that marries tradition with technology, blending the ethos of our justice system with the innovative tools of modernity. Lexits aim to improve and is more than a service. It aspires to be a movement, fostering a culture where justice is not delayed, costs are minimized, and time is respected. This platform has no confines or fixed boundaries. It is for the pre-litigation. Its comprehensive approach spans pre-litigation advisories, mediations, arbitrations, litigations, and post-litigation solutions, and all alternate means as available. It is designed to serve the corporates, foreign nationals and entities also who have invested in India while addressing the unique challenges of compliances and the legal framework and of our expanding economy. None of this could have been possible without the support of our exceptional team, dedicated partners, and all of you who have joined us today. Your presence is testament to the importance of this initiative and shared commitment we hold as a just for the society. As we proceed with today's program, I encourage each of you to deeply engage yourself, contribute meaningfully, and together make Lexits a defining success. Let this launch be the beginning of a movement and a journey that sets benchmark in legal services and aspires others to innovate for the greater cause. Thank you once again for honoring us with your presence. Let's embark on this transformative journey together. Welcome to Lexits, an initiative of S.K.Singhi and Partners. Thank you all. Thank you.
Thank you very much, sir, for addressing us and also for letting us know more and in detail about Lexits. Thank you very much. Ladies and gentlemen, as sir said, that Lexits is not going to be a luxury or an option, but a total necessity. So all of us will join in the beginning of a movement in legal services, as rightly mentioned. With this, may I take the opportunity of now requesting the address by Dr. G. Satish Reddy, former chairman DRDO, and आपसे निवेदन है सर, प्लीज अपने शब्दों से हमें एनलाइटन करें. जोरदार तालियों के साथ स्वागत डॉक्टर जी सतीश रेड्डी.
Namaskar, Honorable Sri Venkataramani ji, Dr. Lalit Bhasin ji, Dr. Manoj, Sri S.K.Singhi ji, Mrs. Singhi ji, Harshvardhan Singla ji who is here, eminent personalities, primarily from the law and legal and justice related areas who are here. Namaskar to all of you and Happy New Year to all of you. At the outset, let me congratulate Mr. S.K. Singhi for taking this initiative of providing legal aid to the people who are primarily uninformed to take a proper way forward, and providing a platform for that and trying to provide support to them and in turn reduce the huge burden which is coming on to the various courts in the country. I think many people will try to follow and take this at various levels in the country and try to utilize these platforms and take the right course of action what they face of various problems in their life. And as far as this platform is concerned, as Mr. Singhi told me, that primarily it is a technological platform using the technology, mostly trying to provide the online services to various people who want to have this legal aid is one of the important things. In fact, I actually wondered, I didn't think so earlier, but when discussed with him and a couple of other lawyers and all that, law firms or law in the country are related is one which is using technology in a big way. Coming to AI, artificial intelligence, as a system-wise, law and justice related firms are the ones which are using AI in a big way in the country. I didn't know this till recent interactions with people connected to that. So it is really a good situation that law firms and related activities using the technology which is upcoming in a big way today and try to provide the service or aids in a quicker manner and get the data also in a quick manner. I also request Mr. Singhi ji that once you have taken this activity, which is really praiseworthy, try to provide a timely advice and timely support what is required, because any delay and or any support or activity which is not timely is no support. So see that how quickly you are able to respond, how quickly you are able to provide service is one of the important things. So you need to work out details and the mechanisms, how you can do that is one of the important things. And second, also, I say that let it not be very formal thing. They should be somewhere feel that efforts have been put in and you are sincere to the task what you have taken up, and people should feel that it is, they mean it, what you are saying. That is one of the important things what I feel that it should be done. Once again, I appreciate the initiative by you, and I am sure the learned people who are here with the knowledge what they have got will be able to provide necessary guidance and support to you and take this forward so that the needy in the country, the uninformed people in the country, or maybe sometimes informed people in the country will get the right advice at the right time. My best wishes to you and everyone here. Thank you very much. Jai Hind. Namaskar.
Thank you very much, sir, for giving us your well wishes, and we totally agree that we have to make sure that we provide timely advice and timely support to the ones in need. Ladies and gentlemen, we were listening to the Chairman Intellect Advisors, Lexits, Dr. G. Satish Reddy, and now we move on and invite Chairman Academic Council Lexits, Dr. Lalit Bhasin, President of Society of Indian Law Firms, to please address the August gathering. Let's welcome sir with a big round of applause.
Thank you, Mr. Venkat Ramani, Dr. Manoj Kumar, Dr. Satish Reddy, Mr. S.K.Singhi, Mrs. Urvashi Singhi, Justice Rajesh Tandon, Justice Bayana, my friends from the bar, Mr. Asim Chawla, my friend from Paris, Mr. Phadke here, all other distinguished members of the bar, academicians, the law teachers, students, and also representing the gender sensitization, we have Madam Neena Gupta here, who's a member of the Supreme Court appointed Gender Sensitization Committee. I bring to you greetings from the Society of Indian Law Firms and also from the Bar Association of India and the Chartered Institute of Arbitrators, as also the CII National Committee on Legal Services, which organization I head at the moment, you see. We have done, I think, enough lip service to the cause of dispute resolutions. Litigation has totally failed. As rightly pointed out by Mr. Singhi, more than 5 crore cases are pending all over, and they are increasing. Technology has come, but it has also brought in the ease to initiate legal proceedings, but there is no ease to dispose of the cases which are continuing to be increasing, you see, day by day. Arbitration, thanks to some initiatives by the present government and particularly by our Attorney General, who has taken the lead in this matter by bringing arbitration back into the focus, because even that has virtually had failed to take off because of the long time it takes to settle arbitration proceedings. It has become very expensive also. The initiative taken by the Attorney General definitely is a step in the right direction, and we hope that arbitration would eventually take off in this country. Mediation now again, thanks to the government and initiative, and we have the additional secretary, legislative section with Dr. Manoj Kumar here, who has also taken steps, you see, to promote and to advise the government to bring in legislations which promote settlement of disputes. The mediation law is there now. But has it helped anything, you see, to reduce? That is where the role of professionals come in. Mr. Singhi's initiative is very innovative. It is a way of giving back to society. His firm is one of the most distinguished law firms and member of the Society of Indian Law Firms. By introducing Lexits, he is not trying to promote his law firm. What he is trying to promote is a higher cause, you see, of bringing justice to the people. That is what Mr. Singhi has done, and I think it's a very commendable thing. As I said, from lip service, now we are going to active service to the poor, the needy, whosoever needs that. Not only that, in order to promote disputes even before mediation comes in, even before arbitration comes in. It's one of the most brilliant initiatives taken, and we strongly support that as Society of Indian Law Firms, as the Bar Association, as the Chartered Institute of Arbitrators. We fully support that. Only one thing has to be kept in mind, that it should not be, Lexits should not be confined just to lawyers and judges. I think we have to broad base it. I'm very happy to see that the former chairman of DRDO is present here, you see. So we have to involve cross-section of people in order to bring justice to the people. There should be chartered accountants, company secretaries, technocrats, you see, the engineers, architects, everyone should be involved in this exercise. Should not be just confined to lawyers and judges. And what is required also is that we as professionals, and I've coined that phrase, should engage in professional social responsibility. Professional social responsibility also includes creating awareness among the people, bringing about a change in the mindset of the people that let us try to resolve our disputes. Let us try to solve them rather than going, you see, to courts or arbitration or even mediation. Why can't it be done at the threshold itself? And that is where, you see, Lexits can play a very important role. So it's a brilliant initiative. I compliment to you, Mr. Singhi, and extend to you full support from the various organizations. Thank you very much.
Thank you very much, sir, for your well wishes. And as you rightly mentioned, that this initiative is very, very innovative. So let the initiative be beneficial to the entire humanity. With these prayers, we move forward. Ladies and gentlemen, we'll now have the opportunity of being addressed by our guest of honor, Dr. Manoj Kumar, Additional Secretary, Legislative Department, Ministry of Law and Justice. Please put your hands together as we welcome Dr. Manoj Kumar.
Learned Attorney General for India, Shri R. Venkatramani ji, Dr. Lalit Bhasin, Shri Satish Reddy, Mr. Singhi and Madam Singhi, and a galaxy of luminaries present here today. Good morning to you. It was very interesting to see the outline of Lexits initiative that Mr. Singhi very eloquently presented to us in the beginning. Something that I picked up from some of the reading material shared with me is that the driving underlying motivational track for Lexits is it's better to talk and settle rather than engage to fight, and which is a very commendable thought and something that is very crucial for every litigant to consider and evaluate. Well, having said that, technology is not new in India with respect to access to justice. We have had initiatives which are driven by technology by the government itself and by other private players and aggregators. We have the e-courts project, we have the tele-laws initiative. As the legal fraternity, we would be aware of them. We also have a few free online legal aid platforms, pro bono platforms like iPro Bono, Nyay, Law Rato, Legal Cart. They all kind of try and enable support to litigants free of charge in different aspects. In fact, even for online dispute resolution, we have now SAMA and ODR ways as to other initiatives. Now, the novelty that Lexits brings is an evaluation or assessment of what is likely to be the outcome of initiating a certain litigation or a case by a litigant. The winnability factor is something that is proposed to be advised to a litigant based on a lot of AI environment created from case laws and predictive technology, and of course, applying them to the facts and situations of each case. It's a very commendable initiative, and my congratulations to Mr. Singhi and his team. Well, this is where I would like to also want to contribute a few thoughts that who is it supposed to be intended to? We have a broad spectrum of litigants in India. We have the corporates, we have the individual HNIs, we have other classes of litigants who could be employees, who could be contractors, who could be property owners, and so on and so forth. In the era that we stand today, and with the motivation that Mr. Singhi spelled out on access to justice for all, I think it's very, very crucial for Lexits to focus on providing this support to targeting individuals and classes who are economically, socially, or otherwise disadvantaged and face systemic barriers. A few days ago, Mr. Singhi had very kindly dropped by to see me, and we discussed the outline of Lexits initiative. And it turned out that the initiative has a certain cost to it. A litigant would have to pay a certain nominal fee. However nominal that is, it's a very relative term. And I urged Mr. Singhi to also try and make it available to certain sections free of charge. It could be based on a financial threshold. It could be based on a nature or class of a dispute. I'll try and give a flavor of some of them as we go forward now. Economically weaker sections, individuals who are challenged by level of income, or they are below a poverty line, and they actually end up in a situation where they are disadvantaged, or they have a less against somebody who they are not able to compete with because of financial handicaps. Could we explore to give them, of course, subject to verification of their status as an economically weaker section person, provide this service free of cost? Women and children, women who are facing domestic violence, for example, they may not have a case which has a monetary value, but they definitely need to have access to justice in a system where, unfortunately, they have to face the same level of challenges that somebody who is making a monetary claim has to face. So a woman facing domestic violence or harassment at workplace or custody battles, children who need protection, or various matters under the juvenile justice system, they are financially disadvantaged. A few other classes, persons with disabilities, with persons with physical, mental, or sensory disabilities. Now, how could they be made aware that this kind of a service is available, and how could the service be reached out to them so that they could benefit, is something that I would urge from the technology perspective, the outreach perspective, and also for access to this technology by persons of disabilities. Victims of human right violations, it could be bonded laborers or survivors of trafficking and so on and so forth. Rural population where in very remote rural areas. Fortunately today we have seen the digital India transformation over the last few years, and I think those days are gone when the outreach of technology was not possible. I think digital India has made even the remotest areas, persons in remotest areas connected for any kind of a public service delivery system through digital means. This could, of course, stand in the same footing. Therefore, although they are in rural areas which are otherwise remote, be it in Chhattisgarh or any other similar place, but an access to a platform like this where even a person there could assess winnability, and therefore, although they are fighting with challenges of financial means and so on and so forth, they could also benefit from Lexits. Workers in the informal sector, domestic workers, daily wage laborers, migrant workers, they all have a mobile, and they all use apps, and we will be really surprised when we actually see them using the digital features that the mobile phone is able to deliver, right from UPI and so on and so forth. So could this particular platform be also made available, and could they identify themselves when they open the mobile app of Lexits that, okay, this is for me, I can actually access it, rather than being scared and intimidated that this is meant to be for somebody with means and to have a dispute of a certain value. Elderly citizens, senior citizens and abandoned, especially citizens who are abandoned by families, and of course, last but not the least, survivors of disasters, survivors of natural calamities, industrial accidents, and similar classes. So in one short point, could we make this something which is available to the sections of the people who would otherwise not be able to access it unless we structure it in a certain way? And could this therefore be the contribution of Singhi and Company and Lexits in nation building at a time when we are celebrating the 75th year of our Constitution, when we are celebrating constitutional guarantees being available and accessible to every citizen of the country. The other point I wanted to also flag is, I'm not sure whether the feature covers it, is would this be also advising a litigant what track to take, whether to go to a court, whether to go to initiate arbitration proceedings, whether to initiate a mediation proceeding, or ODR, for example, which could be a much cheaper and on the face of it, a justice delivery system available right at the doorstep, in fact, in the palm of the person. So if, apart from the winnability, also the cheapest and the most efficient way to get the access to justice would be very good if they could be brought into the features of the platform. I think by targeting these groups and access to free technology for legal case assessment can become a transformative tool in achieving justice for all in our journey to achieving a Viksit Bharat by 2047. My best wishes to the initiative and Mr. Singhi and his team. Jai Hind, thank you.
Thank you very much, sir, for addressing us and enlightening us with your words of wisdom. Moving from tradition to technology, and as you rightly mentioned, that making Lexits available and accessible for all, irrespective of their prevailing conditions. Thank you very much for your address. Ladies and gentlemen, it is with great honor and delight that we will now invite our respected chief guest for the day, Mr. R. Venkatramani, Learned Attorney General for India, for his address now. Please join hands in welcoming the chief guest for his address. जोरदार तालियों के साथ आइए अभिनंदन करते हैं. बहुत बहुत स्वागत, बहुत बहुत अभिनंदन.
Bharat Mandapam has been reverberating with initiatives ever since the G20 took place here. And every initiative that happens here, I'm sure will have a great beginning and a great progress. And I congratulate the Singhis to having chosen this place for this wonderful initiative. And in addition to that, you have a bonus of Mr. Lalit Bhasin here. His Maida's touch. You know, it's like a Maida's touch. Everything it touches gold, and it makes things move in a big way. And you have a great godfather in Mr. Lalit Bhasin being part of this initiative and being here to congratulate and appreciate and extend all the possible support in times to come. Now, how do we look at a subject like this? In the domain of technology, people began to talk about different ages of technology, or different machine ages. So we had for a long time, ever since the combustion engine was discovered, what's called the dumb machines, machines which we could operate at our will and subject to our instructions. So we had an operating manual of all the machines which we had so far invented, discovered and made as part of our life. But they were subject to our control. But as we moved on to a different machine age, as they call it, everybody who writes about the different machine ages talks about the motion or a transition from dumb technologies to what called participating technologies, or even more interactive technologies. Some time to come we will have technologies which probably be part of our life so unconsciously that we may not even notice how we are using this technology. Like the little mobile instrument we use today, without which will become almost paralyzed, right? And so we are slowly moving towards this age of from a dumb to a more participative technology. But how does it make sense for law and justice? Now we have for a long time lived with the adversarial legal system. And it's one of the best legal systems probably humankind ever discovered, despite all the distinctions between civil law, common law, and all those kind of very minor distinctions in law. So the adversarial legal system has given us the benefits of discovery of truth in a more neutral way, as we call it. But then as we go forward, and we went forward in the use of the adversarial legal system, we find that it has allowed itself in a way, for reasons which I'll briefly now talk about, allowed itself in a way to become exploited and manipulated. The discovery of truth, when Justice Malimat Committee report was given along with Professor Madhavan being part of that. So the discovery of truth has become a casualty in the hands of the adversarial legal system, as that particular report talked about. There was a lot of hue and cry about that report at that point of time. I think we were not ready and willing to receive that report from a futuristic point of view. So when you talk of predictive legal solutions and technology being used for predicting what kind of an advice would suit and all that kind of subject, I think we are talking about a futuristic vision of discovery of truth. Now, people who write about artificial intelligence, including that wonderful partner in DeepMind, Mustafa Sulaiman, he talks about what adventures we may encounter in the use of artificial intelligence. A lot of literature is being written about how artificial intelligence can be brought into service to serve humanity. There are many open questions, and we may still not have answers both from scientist, technological and sociological point of view. But I suppose when we use certain terms like the artificial, we only are using a word which is not probably for use of another word which we not yet discovered. So it is all the intelligence which current technology has been able to discover is in the service of humanity. And it is like an agent. So we are the principal, artificial intelligence will be our agent. But how far it can be our agent, and as I said, we went to the next stage of participating technologies. How will they help us and guide us in understanding our law and justice administration? That's why I think it's important for us to look at very closely at the adversarial legal system and how soon we would be ready and willing to dismantle it. I'm very clear about what I'm thinking. How soon we'll be ready and willing to dismantle the adversarial legal system. Then one will begin to talk about, the legal health of a community. These are a term which is being often used in some legal literature to talk about, as one can say, the gross domestic product. Economists talk about that. So why don't we talk about the gross domestic justice, gross justice efficiency and the gross justice expedition? Can we expect a gross justice expedition with the adversarial system on hand? So howsoever one may play a part in the adversarial system, as long as we don't probably invent systems of law and justice, which will not merely be adjuncts, but completely alternate in substance, procedure, and all that way one looks at it. And therefore, we look at all that from a very fundamentally, radically different angles. It's in that context I look at initiatives like this, which will probably usher in new ways of understanding what we can probably continue to think about the gross justice efficiency and the gross justice expedition of our administration of justice system. So how do you go about it? And as the Additional Secretary mentioned, the technology which you're talking about today, all the digitalization, the e-court, e-filing, etc., are to ease the burden of an existing system. But by easing the burden of an existing system, are we really easing out of the system? I think the answer is no. But it's important to begin with easing the burden of the system. The physical code, the physical processes, motions, and then transactions in the physical world, which occupy a wide range of economic costs, environmental things like etc., etc. I think once it's important that we move into the digitization of the entire justice system. But then probably that will be only one answer, a one-step answer. An immediate answer we require, of course. But do we stop with that? I don't think we'd stop with that. Probably it will enable us sooner or later to find out how best the next generation of technology for justice administration. And it will not be any artificial intelligence like any other use in the general community participation. I'm looking at an intelligence development, technology development, which will be more suited and more related to justice administration. I am sure technologies in our country, with leaders like Satish Reddy heading in the DRDO, will be able to look at what kind of technology initiatives will be more suited and required for justice administration. I'm sure we'll discover all that very soon with the government standing behind us with all kinds of support to be available to us. But I'm looking something beyond that. And when lawyers, the way we practice law today, is so tuned to the adversarial system. The advice I give to a client and the way I would like to navigate the course of a case from the trial court up to the Supreme Court, how do we really navigate them? At every stage, at every point we navigate the system, I find we are caught in the adversarial dimension. Somewhere, I think it's so deep in our mind. So every thought, every idea, every advice I give to my client is so confined and so conditioned by the adversarial mentality. So I think, do we think can we come out of that? We've been talking about mediation as another alternative of looking at dispute resolution. But as long as we consider it again as an adjunct to an existing adversarial system, mediation will continue to be a small limb. It will not become an important, independent working system by itself. So whatever we are talking about today, arbitration, mediation, they seem to be some kind of an adjunct limbs to the core adversarial system. So instead of becoming and continuing to be adjunct limbs or merely service providers to ease the burden of an adversarial system, unless they become independent institutions and procedures and processes. And then how can they happen? It can happen only when we probably internalize different methods and different ideas looking at justice administration. And that's where I think initiatives like this will play a very important role. And I'm sure that initiatives will not stop by giving a client advice. The moment you get into this kind of initiatives, I see a larger futuristic possibilities and potential. And the younger generation of law students and lawyers will probably be able to think beyond what we have been trained to think. And I invite each and every one of you to go beyond, transcend the conditions, the confining conditions, the adversarial thinking modules, and to see how, and also look at the different legal dimensions of a country like India. Mention was made about the Domestic Violence Act, and a wide range of different sections of our community have different justice needs. We create them by distinct kind of legal frameworks. But all of them seem to be revolving around one central mode of dispute resolution. So a Domestic Violence Act will have to go to a family court. Look at the family courts, how they perform. So look at every court system which we develop, the banking system, right? Then we are now into IBC. Look at every system which we have developed, and then but we have injected somewhere or the other what I would call the unfortunate creeping element of the adversarial systems. As long as we live with them, I do not think that what I may call the gross justice efficiency and gross justice expedition can ever be given birth to. Therefore, I invite all of you and to think and go beyond our current ways of thinking and looking at justice and lawmaking. That's why we thought lateral interventions in the civil service, like we brought Manoj Kumar as part of the civil service here today. We would like to have the government be open to bringing more and more lateral initiatives and interventions from citizen participation. So it becomes governance also becomes open, transparent, participatory. And the way, of course, several government departments function today, given my little experience as an Attorney General, I could sense how we can plug many of those little unseen, unperceived holes. And once you start plugging them, I'm sure what I may call the citizens' participation will become more and more effective and encouraging. And if there is no encouragement, there is no incentive, how do you think a system will ever live in a healthy way? Therefore, they are very important questions for students of law and young lawyers to think and continue to think. And I find there are some academics here. I'm sure our law schools will also start thinking on those lines. And unless the law schools begin to think on those lines and trains the mind of the law students to look at how justice administration must have certain inherent norms and principles without which you cannot say it's a healthy system. Therefore, it's beyond studying certain subjects of law. It's important that after all you study certain subjects of law for doing what? Ultimately for having a justice element brought into our subject and study of law. So I invite the law schools and heads of initiatives as law schools to bring in more and more such thought processes into our study of law. And as I was invited to come here today, I would not take much more of your time. And for quite some time, I've been thinking about how government initiatives can also be more broad-based. So we started with a national litigation policy, and very soon probably the national litigation policy with its minimal technology, initiatives, and then will all probably be shared with the community. And we invite law students, lawyers, and the academic community to participate in this litigation management policy as a national concern. Because it's not merely a concern of judges and lawyers, it's a national concern. So the second initiative we've been thinking about is how to have a interdepartmental collaboration and cooperation using technology, so that people will know at what point of time citizens can know what is going to be an outcome of a given deliberation at the government level. Also going to probably facilitated by technology. So I think that's going to be a great walk into the future. And long ago, I think it's somewhere in 1930, the great English economist John Maynard Keynes said, in my great-grandchildren, my putative grandchildren, will probably work only for 3 hours a day. Machines will take over the kind of the rest of our hours of working, thinking, and thought process, etc. That's on the one hand. Probably we are reaching that very soon. But that cannot be an ideal way. It has to be an active interaction with technology. And that's one way of looking at it. The other issues where we are talking about technology becoming an intrusive thing. Like long ago, it was in the novel 1984, it was said a thought machine can be invented in some point of time in future. So anywhere around this place, you will have a thought machine unknown to you, reading your thoughts and minds. And then that brings a great amount of alarm. My privacy. What about all that? So between two extremes of technology, we have a middle path where if you're able to determine what technology will do for us as our agents, not as our dictators and directors of a course of action. I think that's where the genius of Indian technology initiatives will probably determine how it's going to happen tomorrow. I thank the Singhi family for calling me here today, and I deeply appreciate this initiative, and I'm sure whatever little way the Office of Attorney General can put in little efforts, and it's there available to you. And once again, I think please go ahead with your initiative, and the warmth which you have brought in with the people you have invited you today will live with you forever. And thank you for calling me again today. Wonderful day for every one of you.
Going beyond our current ways of thinking, taking these learnings forward and building on the work that has already been done. Thank you very much, sir, for your words of wisdom. Thank you for enlightening us with your address and putting forth your thoughts, views, and ideas on this momentous occasion. Thank you very much. Ladies and gentlemen, the moment has come for which all of us had been very eagerly waiting for. And this is going to be the unveiling and inauguration of Lexits. May I please request our Honorable Chief Guest to kindly unveil and inaugurate Lexits, and also requesting the other dignitaries on the dais to kindly please join in this unveiling. निवेदन है मुख्य अतिथि महोदय से कि कृपया Lexits को लॉन्च करें, इनॉग्रेट करें, और जितने भी गणमान्य अतिथि मंच पर उपस्थित हैं वो सभी ज्वाइन करें. सभी की ओर से जोरदार तालियां. Ladies and gentlemen, please join hands as we unveil and handing it over to Shri S.K.Singhi for taking forward this initiative. A big round of applause, ladies and gentlemen, for taking this initiative forward. Presented to Shri S.K.Singhi. May we please request our team to play the video, the Lexits video now.
Welcome to Lexits, an innovative initiative conceptualized with the expertise of S.K.Singhi and Partners LLP, yet functioning as an autonomous platform committed to reshaping the legal landscape with clarity and purpose. At its core, Lexits focuses on pre-litigation advice and tailored litigation portfolios using predictive analysis to empower litigants with informed choices. Our mission is simple yet transformative: to reduce judicial backlogs, manage disputes efficiently, and offer cost-effective solutions that save time and effort. Guided by its patrons and advisors, Lexits will endeavor to deliver comprehensive and customized strategies for every case. By leveraging cutting-edge tools and expertise, it illuminates likely outcomes, associated costs, and alternative paths, enabling individuals and businesses to navigate legal complexities and decision-making with confidence. Lexits serves as a resource for global stakeholders interested in navigating India's legal and business environment. More than a service, Lexits is a commitment to empower litigants, enhance access to justice, and foster a progressive judicial ecosystem. Welcome to the future of legal innovation. Welcome to Lexits.
A big round of applause. Commitment to empower litigants. That was a wonderful video. Ladies and gentlemen, after the unveiling and inauguration of Lexits, we will now be launching the platform and website of Lexits. May I please request our Honorable Chief Guest to please launch the website of Lexits. इस टैब पर क्लिक कर आप प्लीज लॉन्च करें और हम सब लोग ज्वाइन करेंगे इस लॉन्चिंग में. लेडीज एंड जेंटलमैन, दिस इज द लॉन्च ऑफ द वेबसाइट एंड प्लेटफॉर्म ऑफ Lexits. Thank you very much, sir. आचार्य महाश्रमण जी का भी आध्यात्मिक जो उनकी विशेष हैं, आध्यात्मिक मंगल कामना हमको मिली है, हम उनका भी बहुत बहुत आभार करते हैं. Ladies and gentlemen, as we move further, we will now be inviting another luminary, Mr. Ajay Vadva, President, ITAT Bar Association, New Delhi, to please address us. Please join your hands for Mr. Ajay Vadva. Mr. Vadva has been an advisor of the taxation study book of the NIRC of ICAI for more than 5 years. He has delivered more than 200 lectures across the country and is currently the president of the ITAT Bar Association, New Delhi. We welcome you, sir, and request you for your address.
Hello. Yeah. Shri R. Venkataramani, Shri G. Satish Reddy, Shri Lalit Bhasin, Shri Manoj Kumar, Mrs. Urvashi Singhi, and Mr. S.K.Singhi. My esteemed colleagues, ladies and gentlemen. So, when I received the invite, it mentioned that the focus is going to be on civil and criminal litigation. So I promptly invited Shri S.K.Singhi to my house, served him pakoras and sandwiches, and said, well, listen, what about taxation? I've been dabbling in tax for nearly 35 years. And why would you not include tax? This is where maximum litigation is emanating. And I would say fruitless litigation is emanating. You're very kind. We also visited the tribunal where I am the president of the bar, and there interacted with the Honorable Vice President, and perhaps now I have to make out a case here before this esteemed audience and the chief guests that taxation has to be taken into its fold and is very important for the development of the country, and therefore I'll place my submissions before you as we do in the court, and let's see if I'm able to succeed. Now, at the very outset, on my own and on behalf of the ITAT Bar Association, I extend my heartiest congratulations and profound gratitude to Shri S.K.Singhi for conceiving this innovative concept of Lexits. This initiative aims to discourage indiscriminate court filings
and promote alternate modes of adjudication, including conciliation, mediation, and arbitration. This endeavor addresses a pressing need in a country arguably one of the most litigious globally. If effectively implemented, it'll unclog our higher courts, enhance the ease of doing business, and foster economic growth. Sir, I am a tax lawyer and therefore better equipped to discuss how tax department and taxpayers contribute to countries' overburdened higher judiciary. In my view, we need to address the real reason why people rush to the higher court for help, and certainly they're not very hard to spot. Sir, in my view, to a very large extent, it's the abdication of duty by the administrative and quasi-judicial authorities and the unusual delay in decision-making, which is a cause of the matters ultimately landing up in the court for SACA. Take the example of the Income Tax Department. Sir, over 5 lakh cases are pending before Commissioner Appeals, many unresolved over 5 years. In several instances, the government has already recovered 20% of the tax, yet the appeals languish unheard. Well, this compels taxpayers to escalate matters to higher courts for relief. And such delays create an image of tax terrorism, deterring domestic and international investment. Many appellate institutions, like the Commissioner Appeals, the dispute resolution panels, have become pass-through entities, with taxpayers reposing greater faith in the tribunals and higher courts to resolve their disputes. Their order often fail to follow judgments from the higher courts, cite frivolous distinctions, or ignore clear directives. Sir, what I'm trying to get at is that unless and until the administrative authorities and the lower appellate authorities do their job properly and do not become pass-through entries where people only say, well, decide the way you want to, we'll ultimately go and get justice from the tribunal or the high court. Things will not improve. After all, that's the catchment area, that's the problem area. That's where people are jumping the gun to go to the higher courts to get justice. Now, another example, sir, which I'm sure a lot of us would be facing on a daily basis. In so many cases, refunds are arising out of relief given by appellate authorities not giving on time. This results in the taxpayers knocking the doors of the courts, and once they approach the court, the refund comes within 2 months. Now, how does that happen? If the court is to direct that refund be given, which ought to come in the normal course, I win an appeal, I paid an excess tax, it should come to me. But you have to go to the courts. And sir, I was discussing yesterday with some very senior law firm. They said we've got standard templates where all the chartered accountants and lawyers have to do is fill it up and go to the court for a refund. Now this is frivolous, absolute frivolous, wasteful litigation, sir. Now, writs are filed where we see often for lack of opportunity allowed by the lower authorities, not show cause notices not given, not confronting evidence, not allowing cross-examinations, not following the principles of natural justice. One fails to understand why these fundamental settled issues one has to approach the court repeatedly. Now, then lack of drafting of laws is another reason. Proper drafting of laws, giving examples, giving the intent is another reason why the courts are flooded. Sir, a case in point is an amendment in 2021 on reassessment. Section 148 was introduced, and on one circular, reading of the circular, 90,000 writs were filed. I've never seen so much litigation on just one circular reach finally the apex court. 90,000 writs and many more emanated from there. Now, again, that's avoidable. Then procedural flaws in legislative and administrative framework create unnecessary litigation. For instance, now, sir, once a jurisdictional high court decides a writ on a legal issue, then all similarly placed assessees should ideally benefit from that. Why must each individual file a separate writ on the same problem? to get relief and waste the valuable time of the court dictating the same order over and over again. That's another problem. So one writ, legal issue decided by the Judicial High Court, and everybody has to follow suit because the writ is a decision in personam. You have to go, everybody has to go and get the relief. Now, that is again, so much of wasteful litigation, sir, which I have seen. Now, another required area of reform where lesser crowding will happen is the appointment to the tribunals across the country. Sir, earlier, at least in the income tax tribunal, members would be appointed and they would live, they would grow within the tribunal, understand it, and understand the law. Now what has happened is, we've got Agniveers in the tribunal. They come only for 4 years. Now, which good professional would be interested in joining an institution only for 5 years? They would not. Then there must be continuity, and one must feel wedded to the institution rather than treating it as a parking lot. The second issue is the selection process itself, sir. Now, unlike rigorous procedures for selecting members of the tribunal in countries like the US, UK, Canada, India's process involves a brief 15 to 20-minute interview. Now, this is insufficient for assessing candidates for such a critical role. The solution involves a multi-tiered process involving written tests, situational judgment assessments, and comprehensive background as it is done elsewhere in the world. In 15-20 minutes, how do you select somebody of the level of the Secretary to the Government of India, having to dispense justice as the final fact-finding authority and expect the very best to get in? Now, that's been, again, a problem, sir. Now the latest trend is that the selections are now being made from retired departmental officers who have lost touch with quasi-judicial functions and have been functioning as administrative authority for years together. We need younger, enthusiastic professionals and officers who have genuine interest in law and want to make a career in government as judicial authorities. That's the need of the hour. Perhaps a judicial selection or a judicial forum, we need an alternate where people are groomed to become judicial officers at the lower level. Now, sir, the income tax department no longer has a dedicated settlement machinery. Every case lands up in the court. There used to be an income tax settlement commission established in 1970, aimed to resolve disputes swiftly and reduce litigation. Did a human service for taxpayers and the department and settled matters amicably, ensuring that there was no loss to revenue as well. Abruptly, it was demolished. It was done away with in 2021, primarily, according to the finance minister herself, that the decision-making process and disposal rate was very slow. Now, that was the reason given why Settlement Commission itself was abolished. Now, the commission used to settle highly complicated search-related matters. Now, with its abolition, litigation in matters continued its long waiting journey to higher courts and the Supreme Courts. Its revival with fresh ideas is the need of the hour and could be transformative. To ensure impartiality and domain knowledge, a restructured commission includes experts from diverse backgrounds. Transparent selection process should happen. Clearly defined timelines for case resolution will restore public confidence in the system. And sir, I'll just catch a very important word the Honorable Shri R. Venkataraman said, phrase, that the reconciliation or the alternate dispute mechanism has to be delinked from the adversarial system. Now that's extremely important. Imagine if you have a settlement machinery which crisscrosses in the income tax department or elsewhere, crisscrosses the routine formalities of giving 10 days notice or where notices have not been served, the assessment need not be quashed. I mean, those technical issues could be overcome, adversarial system could be dispensed with, and as a standalone basis, have confidence on these systems, have confidence in these commissions, and allow things to happen. Now, another solution, sir, to improve procedural efficiency is the extensive use of artificial intelligence. Automated systems can flag cases and grievances pending beyond stipulated timelines, holding officers accountable without requiring intervention from higher authorities. Just to give you an example, sir. Now, sir, there was a refund arising, a huge refund arising on account of an appellate order. We write 15 times to the lower authorities, kindly issue the refund. We ultimately go to the chief commissioner, the principal chief commissioner, and they have to issue an order. Well, do what you have to. You are supposed to issue a refund within 2 months. Why haven't you done so? Now imagine if we had used the AI in this, that once I make a claim, a red flag has to come up within 2 months, and the AO has to automatically answer the assessing officer as to what should be it. So that is another way. Now, sir, finally, I feel there's another case, Mr. Singhi, if you can consider. We must have a think tank of experienced judges, lawyers and chartered accountants who should closely associate with and work with the various wings of the government. This would give them a perspective on how laws should be drafted and proper procedures for the implementation set in place, which, if tested, would pass the muster of the higher authorities. Sir, India stands at a crossroad where decisive action can transform its legal and administrative landscape. By reducing the judicial backlog and fostering a transparent tax administration, we can shift from an adversarial system to a collaborative one. This will enhance compliance and bolster the confidence of investors and taxpayers alike. Thank you very much. Thank you.
Moving from an adversarial system to a collaborative one, the golden words rather. Thank you very much, sir, for addressing us and sharing your thoughts with us on this momentous occasion. मैं निवेदन करना चाहूँगी अजय वाधवा जी से कि कुछ क्षणों के लिए वापस मंच पे आएं, क्योंकि हम आपको एक स्मृति चिन्ह भेंट करना चाहेंगे. मैं प्लीज इनवाइट श्री Ankur Singhi, Joint Managing Partner, S.K.Singhi and Partners LLP, to kindly please present a token of respect for Shri Ajay Vadhva. Thank you very much, sir, for joining us here and sharing with us your thoughts, views, and ideas today. Thank you very much. Ladies and gentlemen, as we move further, we would now be inviting Mr. Himmat Mandot, National President, Terapanth Professional Forum, to address us now. Mr. Mandot is the co-founder of As It Is Nutrition and the National President of Terapanth Professional Forum. A national corporate quiz champion with over 35 wins, he has been recognized as a young entrepreneur by Explore Karnataka Foundation and a top seller in health and nutrition by Amazon India. So we have too many credentials. Over to you, Mr. Himmat Mandot.
Thank you. Justice delayed is injustice, and justice speeded up with AI gives peace. I congratulate Shri S.K.Singhi and partners on this noble initiative, Lexits. Friends, artificial intelligence was coined in 1956 by John McCarthy, and for over half a decade, this term artificial intelligence reverberated between in the Silicon Valley and in the minds of techies. Only in the last 3 to 4 years back, we had this ChatGPT coming into the picture and brought this artificial intelligence in the hands of common man. And friends, I hope this noble initiative Lexits will bring AI-based legal solutions in the hands of common man very soon. And I and S.K.Singhi and partners will be remembered for times to come to bring this AI into the hands of common man via this legal resolution. Friends, I represent Terapanth Professional Forum. It's a Jain organization under the aegis of His Holiness Acharya Shri Mahashramanji. We have brought around 11,000 Jain professionals on one platform: CA, doctors, engineers, IAS officers, advocates, and many more professionals. And glad to share that we have 650 advocates on our platform, and we have about a dozen judges on our platform, and our host, Sri S.K.Singhi Saab, is the Chief Trustee of Terapanth Professional Forum, and it's a matter of pride for us, sir. I just want to share one initiative which we are also doing from our side. We have a AI-based solution on WhatsApp made for common man called TPF Paramarsh. What is this? कोई मिडिल क्लास फैमिली है, डॉक्टर के पास जाते हैं किसी कारण से, एंड डॉक्टर सेज कि भाई 20 लाख का खर्चा लगने वाला है आपका, 1 साल का ही टाइम है, एंड पैरेलली somebody visits a advocate for some opinion, नहीं आपका इधर 25 लाख का खर्चा लगने वाला है, and stuff and so and so forth. What does the government man do in that case? So we have this one mobile number 9916691313. I repeat 9916691313. It's a AI based platform on WhatsApp. आपको उसमें सिर्फ हाई बोलना है, and in the field of medical, legal, taxation and career guidance, any individual from India and outside, आपको उसमें फॉर एग्जाम्पल आपका कोई मेडिकल कंसर्न है और उसमें आपको सिर्फ अपने रिपोर्ट्स, MRI रिपोर्ट्स वगैरह हैं, आपको उसमें अपलोड करना है, एंड यू हैव टू मेंशन योर प्रॉब्लम विद इन 24 आवर्स द रियल एक्सपर्ट कमिटी ऑफ TPF, द प्रोफेशनल्स, वहां से आपको जो है आउटपुट मिल जाएगा. यू गेट अ सेकेंड ओपिनियन, एंड बेस्ड ऑन द सेकेंड ओपिनियन द जेंटलमैन कैन डिसाइड the way forward. तो ये एक small cause what we are doing already, and Singhi ji उसमें हमारा already representative है, and I'm sure this noble initiative of Lexits, it's going to be wonderful, and I would also like to see the how is the interface. I'm sure soon we're going to see the interface also. Terapanth Professional Forum is glad to be associated with this event today. Thank you Singhi ji for giving this opportunity. I once again congratulate Singhi ji and partners for bringing this wonderful initiative. Jai Jirendra, Jai Bharat.
Thank you very much for addressing us, Mr. Himmat Mandot. May I please request you to join us back for a few more seconds, because we have a token of appreciation, respect for your joining us here. May I please invite Mr. S.K.Singhi, Senior Partner S.K.Singhi and Partners, to please present a memento to Mr. Himmat Mandot, National President Terapanth Professional Forum. जोरदार तालियों के साथ आइए अभिनंदन करते हैं Mr. Himmat Mandot. Thank you very much for sharing with us your thoughts, views and ideas today. Thank you very much for joining us here. Ladies and gentlemen, before we close the inaugural session, may I please invite and request Shri S.K.Singhi ji to present tokens of respect and appreciation to each of our eminent dignitaries, personalities, luminaries present here with us on the dais. May I please request you to present a token of appreciation first to Dr. G. Satish Reddy. Thank you very much, sir, for joining us here. Chairman, Intellect Advisors, Lexits, Dr. G. Satish Reddy, former Chairman, DRDO. We thank Dr. Lalit Bhasin for joining us here. मैं निवेदन करना चाहूँगी श्री S.K.Singhi जी से कि एक स्मृति चिन्ह, token of respect and appreciation for Dr. Lalit Bhasin. Ladies and gentlemen, Chairman, Academic Council, Lexits, Dr. Lalit Bhasin, the President of Society of Indian Law Firms. और इसके पश्चात उर्वशी सिंघी जी से निवेदन है कि मैडम नीना गुप्ता भसीन जी को सम्मानित करें. A big round of applause to Dr. Lalit Bhasin. I think Mrs. Neena Gupta Bhasin, madam, is gone outside. All right. So we move on, and may I please request Shri S.K.Singhi ji to present a token of appreciation and respect for Dr. Manoj Kumar. Thank you very much, sir, for joining us here. Additional Secretary, Legislative Department, Ministry of Law and Justice, thank you for gracing us with your presence and addressing us. Dr. Manoj Kumar. Please join your hands together for Dr. Manoj Kumar. So Neena ji is here. Neena ji, आपसे निवेदन है कि please मंच पे पधारें. May I please request Urvashi madam to please present a shawl to Mrs. Neena Gupta Bhasin. And post that, we would be presenting a token of respect and appreciation to our respected chief guest for the day. Thank you very much, and may I please request Shri S.K.Singhi ji to present a token of appreciation, respect for our chief guest for the day, Mr. R. Venkatramani, Learned Attorney General for India. Ladies and gentlemen, a big round of applause as we thank our chief guest for joining us here today. A big round of applause. I invite Team S.K.Singhi and Partners to celebrate the launch of Lexits, and we'll also have a group photograph after this. I invite the entire team of S.K.Singhi and Partners to please join us on the dais for celebrating this moment and also for a group picture. Group picture at this momentous launch. On this beautiful celebration, the entire team of S.K.Singhi and Partners to please join us for the launch of Lexits. It is indeed a moment of celebration for all of us here today, and we'll celebrate it with full energy and remember this day by capturing it in the form of a group picture. The team of S.K.Singhi and Partners joining us for a group picture, and also this moment marks the celebration of the launch of Lexits. Ladies and gentlemen, a big round of applause from everyone. Inclusive justice for a progressive world. Thank you very much. Thank you very much, the entire team, and a big thank you to all our dignitaries for giving us your valuable time and being a part of this momentous day. We will now invite everyone to join us for a refreshing tea break, and post that we have some eminent speakers addressing us after the break. We request you to kindly please reassemble at 12:15 and be seated for further sessions. Ladies and gentlemen, tea break के लिए हम सभी लोग अब चलेंगे. Tea will be served downstairs. So एक फ्लोर नीचे की तरफ हमें चलना है. It's going to be downstairs, and all of us will reassemble at 12:15. Thank you very much. Ladies and gentlemen, requesting everyone to kindly take your seats. We are about to begin. सभी से निवेदन है कि अपने अपने स्थान पर बैठने की कृपा करें. पोस्ट टी सेशन अब हम शुरू करने जा रहे हैं. We will be beginning with the panel discussions on really interesting topics. Looking forward to some amazing moments of knowledge sharing. Indeed, this is a platform of learning and cross-learning from each other. Requesting everyone to please take your seats as we should be beginning shortly.
आप यहाँ पे हर्षवर्धन श्रिंगला, मिस्टर हर्षवर्धन श्रिंगला, ही विल बी ऑनरिंग दैम. यहाँ पर है.
आगे क्या है इनका, कुछ डेजिग्नेशन है
वहाँ पे दिया है. इज अ फॉर्मर.
और किस किस को करेंगे फेलिसिटेट?
जो डॉक्टर राजेश टंडन को करेंगे और डॉक्टर जस्टिस एस एल बयाना को करेंगे.
फॉरेन सेक्रेटरी पढ़ के बुलाना पहले इनको.
हाँ, पहले इनको बुला लीजिए.
चलिए बैठेंगे आप?
नहीं, बैठेंगे नहीं, इनको फेलिसिटेशन के लिए बुलाइए. अच्छा. सो what we'll do is we'll start with the felicitation and then we'll start with the panel discussion. And he is on the panelist as well.
या
ठीक है.
तो उसमें लिस्ट में नाम लिस्ट इज हियर.
इसमें जस्टिस राजेश टंडन, जस्टिस एस एल बयाना. ठीक है, वो मैं कल
दो ही
जाना है. अभी के लिए दो ही करना है. ठीक है, आप स्टार्ट करो.
क्या है हमारे पेट्रन मेंबर्स?
ही इज द पेट्रन मेंबर्स.
तो वी वुड लाइक टू begin by
Facilitation of
acknowledging the presence of our patron members.
facilitating our patron members. आप ये ले लो.
Ladies and gentlemen, please take your seats. May I please request everyone to be seated? We're about to begin. Before we begin with the first panel discussion on the topic of bridging borders, comparative perspectives on Indian and foreign law systems, we would like to acknowledge the presence of our patron members and also felicitate them. For doing so, may I please invite former Foreign Secretary, Government of India, Shri Harshvardhan Shringla to please present mementos, tokens of respect for our patron members. मैं श्री हर्षवर्धन श्रृंगला जी से निवेदन करती हूँ कि प्लीज़ मंच पे आएं और ज़ोरदार तालियों के साथ अभिनंदन करते हैं. Ladies and gentlemen, we have amongst us former Judge Uttarakhand High Court Justice Rajesh Tandon. May I please request you, sir, to grace us with your presence on the dais. Please join us. And our patron member, thank you very much, sir, for joining us here today. We're absolutely delighted at your presence. And here's a token acknowledging your presence amongst us. Please put your hands together, ladies and gentlemen. Justice Rajesh Tandon, former Judge, Uttarakhand High Court. Thank you very much, sir, for being here with us. We also invite Justice S.L. Bhayana, former Judge, Delhi High Court, to please join us on the dais. बहुत बहुत अभिनंदन, बहुत बहुत स्वागत. Justice S.L. Bhayana, former Judge, Delhi High Court. A big round of applause for our patron members, acknowledging the presence and felicitating our patron members on the dais before we begin with the proceedings of the panel discussion. Zordar Talia. Justice S.L. Bhayana. Thank you very much. So we now begin with the first panel discussion for the day. Ladies and gentlemen, requesting everyone to please take your seats. As we know that the topic for the first panel discussion is Bridging Borders, Comparative Perspectives on Indian and Foreign Law Systems. May I begin by inviting the panelists to join in first, and then I'll be requesting the moderator to join us. Ladies and gentlemen, please join your hands for Mr. Vijay M. Farke, international lawyer, who's here amongst us. Zordar taliyan inke liye. Mr. Farke is an advocate registered with the Supreme Court of India since 1976. In 1986, he opened an office in Paris to advise French and European companies doing business with India. We welcome you, sir. हम आमंत्रित करते हैं श्री हर्षवर्धन श्रृंगला जी को, former Foreign Secretary, Government of India, to please join us on the dais. Once again, a big round of applause. He's a distinguished Indian diplomat and public servant with a career spanning over 3 decades in the Indian Foreign Service. He has served as the 33rd Foreign Secretary of India, playing a pivotal role in shaping India's foreign policy during his tenure. We welcome you, sir. We invite Mr. Asif Saeed, former Foreign Secretary, Government of India, to please join us on the dais. Dr. Saeed is a distinguished Indian diplomat with over 34 years of experience in various facets of international relations, including political, economic, consular, cultural work, and Hajj management. A big round of applause for Mr. Saeed. We invite Dr. Sumitra Singh, Associate Professor, Amity Law School. She's an accomplished academician currently serving as Associate Professor at Amity Law School, Noida, and an Associate of Honorable Justice Rajesh Tandon. Zordar taliyan inke liye. And ladies and gentlemen, I would now be requesting the moderator to join us, Honorable Justice Dr. Sangeeta Dhingra Sehgal, President, Delhi State Consumer Disputes Redressal Commission. Zordar taliyan. Justice Sangeeta Dhingra Sehgal is a distinguished legal professional and scholar and is currently the President of Delhi State Consumer Disputes Redressal Commission, a position she assumed on May 30th, 2020 after an illustrious career as a judge of the Delhi High Court. We welcome the esteemed panel on the dais, requesting you to please take your positions, and at the outset, welcoming the illustrious panel on the dais once again. And with this, may I please request the moderator to kindly please begin the deliberations from here. Over to the moderator, Honorable Justice Dr. Sangeeta Dhingra Sehgal.
Good afternoon, everybody. I think so, without wasting time, we start with the discussions. I first hand it over to Mr. Vijay Patke, please, to start. Or you wanted to start first. I'm so sorry. Mr. Harshvardhan, please.
Namaskar and good afternoon. And first of all, I want to thank Honorable Justice Sangeeta Sehgal ji for moderating our panel and inviting us to speak. I'm also very happy to share this platform with many eminent legal luminaries, starting with my own colleague and good friend, Dr. Asif Saeed, my good friend, I would say old friend because we know each other for many decades now, although a decade here and two doesn't seem to matter, but nonetheless, Vijay Patke and Professor Sumitra Singh. I, of course, opted to go first because I'm the least educated out of all of my panelists here. I am neither an exponent of law, nor someone who makes policy on law, or anybody, or someone who studies law in the manner that we would do in universities and other academic institutions. But what I do want to share is anecdotal accounts of my own exposure in 4 decades of government service with the legal processes, especially on the subject that we're talking about, which is bridging borders and comparative perspective of Indian and foreign law systems. And in that context, I think transboundary litigation is, I think, really what makes it important to study comparative law, because the incidence of transborder litigation is increasing with more exposure to trade, other exchanges that are taking place between our own country and many countries across the world. Of course, transborder litigation is a complicated affair. It's complicated because you're dealing with different legal systems. There are different cultures involved. And of course, there are different languages that are spoken in different parts of the world. Having said that, of course, I think technology, something that was discussed quite extensively in the first panel also, is playing a major role, and I'm sure our colleagues will speak on many of these things as we go along. Now, when you talk about transboundary litigation, you are talking about litigation that involve individuals, involve in businesses or entities, organizations, and even governments. And what I want to do is to give a brief account of actual litigation that I have witnessed on each of these categories. You know, whether it is at the individual level, whether it is at the business level, whether it is at the business to government level, or G2G, that is government to government. So let's start with the individual to individual, because I think many of you are also students of law, and many of you, of course, are practicing law actively. And some of you have an interest in international law and law when it comes to trans-border disputes and litigation that can actually help in resolving issues between two concerns that are living or are based in different countries. So when it comes to individuals, one case that really, or one sort of case that comes to my mind in more recent years was when I was in the US. I found that parental-child disputes was very, very prominent. That means that one parent or the other is Indian, one parent is in the United States, one of the parents takes the child when there is a marital discord or there is a breakdown in the marital relations and just comes to the other country. Say an Indian parent living in America takes a child and comes to India. So the mother there has no recourse because the child is gone and there is no way that the parents can either share the child, there is no custody battle. Similarly, a parent who's American can just take the child and go to America and then there's no recourse. So there has been attempts at arbitration, there have been attempts to bridge the gaps, but our legal systems are so different and we also have, I would say we don't follow the same conventions. There is a Hague Convention which is related to these sort of disputes which we are not a party to, and so we are not able to really at the judicial level adjudicate cases that are related to parental-child disputes. So what happens is the child comes, say, to India or the United States and has no contact with the other parent whatsoever because it's like almost like an abduction. So these are issues that are of concern, and how can we help bridge these gaps is what I think you will also hear in the panel. One account I would like to give you, of course, is very common, which is basically, when it comes to issues that involve businesses and governments. There is so-called B2G cases. And the case that comes to my mind is a case which involved one of our companies, GMR. You must be familiar because they run Delhi Airport. The Delhi International Authority Limited is a part of the GMR group. GMR had this contract to run Maldives Airport. And they were very good at streamlining the processes. They had started making profits. Maldives Airport was doing very well. But there was a sudden change in government. There was an overnight change in government. The president at that time, President Nasheed, was deposed. The next group that came in were politically, I would say, antagonistic at that time to us. And the first decision they made was to terminate the contract with GMR. Now, this contract was, as per the contractual rules, arbitration would take place in the court in Singapore. Because this is also an important point. Where does arbitration take place? What is the venue of arbitration? So some contracts have it already there, and this contract had that any dispute that would go into arbitration would go into arbitration in Singapore. And it is the Singapore courts that would arbitrate on this issue. And I recall the Chief Justice, because this became a very, very major concern for a country. Both countries were very, very involved because this is a business, that is GMR, that had taken the government of Maldives to court in Singapore, and what would be the outcome? And of course, one thing is that the Singapore process is very quick. They had given a date within days, and the decision was taken the same day. Now, the decision was that GMR must surrender its rights to this airport. And the Chief Justice of Singapore took the line that if the government of that country does not want a certain company to operate, there is no way you can do that. Of course, damages were there, and I think GMR recovered much of the money that they had invested. But nonetheless, I think that case was not satisfactory from our point of view because we felt that this was an injustice. But nonetheless, this is just an example of a litigation between a government and a company. Now, another example of a litigation that involves businesses, which could somehow implicate government also in it, is a case where a number of decisions which were taken, which were post facto decisions by the government of India in the past, actually resulted in commercial disputes that went into the international adjudication process because of the contracts were that way. So in the case of, say, Cairn Energy that had an issue on the tax regime, or the case of Deutsche Telekom, or the case of Antarix, and there are several other cases where such litigation went to courts. And as they went to court, you suddenly had a court giving a decision in favor. But how does this company get back the money that is owed to them by, say, Antrix, that's a government company that owes, say, X money, or the government owes, say, Ken Energy for past taxes paid. So the first thing some of these courts would do is authorize the confiscation of property that belongs to the government of India. So if an Air India plane, at that time Air India was a nationalized carrier, Air India plane lands in the United States, it is impounded. I'm not saying it happened, but there was a distinct risk that this could happen. And we had to take into account the fact that our properties, except for diplomatic properties, could be attached in the United States, in UK, in Europe, in any part of the world. And these courts could actually, make enforcement possible. I think enforcement is also an important issue in this panel discussion, because enforcement is not always possible. But you can, take recourse to the fact that because the government of India owes money to, say, X or Y company, you can attach any of its properties in a certain country and use the proceeds to pay this company. So I think the best possible option for the government of India was to settle out of court, which was done, I think, in all these cases satisfactorily. But these were decisions taken by the previous government on an ex post facto basis, which means that you had a regime in place and decisions were taken that actually went, beyond those regimes. So, I mean, in a certain sense, they were, I think, from a legal standpoint, the decisions may have been open to challenge. The third, of course, is government to government. You have the Permanent Court of Arbitration in The Hague, which deals with arbitration that involves government, and this is governed under what is called the UNCLOS, United Nations Laws of the Sea Convention. And here, of course, Dr. Gandhi, who has just joined us, and a colleague of mine, we were together in the UN mission in New York, is actually an expert under ITLOS. He was our expert of ITLOS, and the UNCLOS process is very well known to him. Now, what are the examples of arbitration? I mean, I myself was involved in an arbitration where we were trying to settle the maritime boundary between India and Bangladesh. Some of you may remember, may not remember, but many of the small islands that came up in the Bay of Bengal were very contentious. There was one island called New Moor Island. We claimed it, so did Bangladesh. Ironically, that island disappeared after some time because it went underwater. So that issue was no longer relevant. But the fact of the matter was that it is important for us to settle our boundaries with our neighbors. So after much acrimony, both countries decided to go to international arbitration, and we also agreed that whatever was the outcome from international arbitration would be agreed upon by both countries. And I remember being very, very integrally involved with the process, along with Dr. Gandhi and many others who were there. And we found that it was quite an expensive process. We had to hire a battery of international lawyers, we had to hire specialists, we had to go into the entire thing. Bangladesh had to do the same thing. And someone said that, international arbitration of this nature under ITLOS, courts tend to sort of go halfway. If this is your claim and the other claim is this way, then you sort of go halfway. And perhaps it came as no surprise to me that when the decision came, it was halfway. In other words, that they gave half our claim to us and half to Bangladesh. And in my view, actually our claim was much stronger, but these arbitration procedures are such that I think they tend to go in a way that is mutually satisfactory. But one final point before I conclude, because I know that Justice Sehgal might be looking at the time, is acrimony, an acrimonious dispute. And one very good example is the South China Sea dispute, where in 1948, when the People's Republic of China came up, they claimed the entire South China Sea through this dubious process called the 9-dash line. Somewhere there was 9 dashes, which suddenly they said that historically, the South China Sea was Chinese territory. It belonged to China historically, and therefore they claimed it. Now, this was certainly not admissible under international law, because what we are saying is that we want a rules-based international order. I mean, what is the Quad saying? What is India saying? What is the Indo-Pacific concept? Is that we want a rules-based international order. What China was trying to say was that we believe this is ours, so we're taking it. Like they did with the Spratlys and Paracels Island. And Philippines took them to court, and they went to International Tribunal in The Hague under UNCLOS. China refused to participate. There is an opt-out clause that they cited. I don't know whether that was legally valid. But the judgment ultimately, without China's participation, went in favor of the Philippines. And basically, the UNCLOS, the tribunal award was that the China had no basis to claim the South China Sea based on the 9-dash line. So in other words, I think this is again an example of international arbitration. But if you look at it in reality, the Chinese still claim that place and nobody has been able to do much about it. But the fact of the matter is that we do strongly believe in an international rules-based order, and we don't believe that such claims which are based purely on your own assertion of what is yours should be admissible under international law. So I want to conclude with just one recommendation, which is basically to say that this entire process that we have witnessed from the morning, which is the effort to have a sort of an e-platform that would provide pre-litigation advice to people. The endeavor is to streamline the legal process and to make it responsive to the people of the country, therefore possibly reducing pendency that is very much there in the courts. This is a very laudable process, and I would suggest, having had the experience as Chief Coordinator of India's G20 presidency, that the recommendations that emanate from this process, at the end of the day, the recommendations would be put together, and these recommendations could be submitted to what is called the Justice 20, which is a part of the G20 under South Africa's presidency. And I'm very happy to say that I consulted both Mr. S.K.Singhi, who is not here, I think, and the Attorney General, Mr. Venkatramani, both of whom agreed that this was a good idea and that we could take the recommendations forward, and that Mr. Srinivasan, who is a very prominent member of the Energy Consortium and community, will chair the committee that will put together these recommendations and hand it over to the Justice 20, which is part of the G20 process in South Africa, which is today the president of the G20. And I think that way we will also take this process, which is a domestic process, into the international stage, and best practices that are instituted as a result of the recommendations and discussions that we have today will form part of the G20's considerations and deliberations as South Africa convenes this presidency. So thank you very much for bearing with me, and I'm back to Justice Dhingra, the chair of our country.
Thank you, Mr. Harshvardhan, for throwing so much of light and in a short time, guiding us and telling us lots about the enforcement of foreign judgments and the other laws and the difficulties which we would face as far as the legal difficulties are concerned. I now hand over to Mr. Vijay Patke.
Thank you, Madam Justice Dhingra. And of course, I must first of all appreciate and thank the Singhi family to giving us this wonderful opportunity to be in this beautiful building and touch upon a very, very important subject that is an initiative which will go a long way to resolve many problems that face the compliance, legal compliances, the delays, and so on and so forth. However, I wouldn't take too much time, as our moderator has warned us, but I would like to remain a little bit anecdotal about my experiences of dealing with laws and practices of different countries, and of course our own country, how it works. And first of all, I must appreciate very much my friend Harsh, who had cautioned us that he knows nothing about law, and he's the only one, but it looks like we have very heavy competition there, and he is someone who knows it quite well. Be that as it may, I would like to just give a few examples of things that happen when we are doing business of whether it is governmental or private sector, not so much at the individual side. This is a very interesting example which I came across when I started my offices in Paris, was in the space, where there was ISRO on the Indian side and the Arianespace on the French side or European side. And this was about the launch of the first INSAT satellites. And we were preparing the contracts, which were, but as it is in many other cases, the Indian government insisted that the law of the contract must be Indian law. And the whole satellite would be launched, of course, from France and so on and so forth. And this was the Ariane 5 rockets. But it came as a big shock to me that such an important organization like ISRO and Antrix and others are going to insist on Indian law as part of the contract. And it was with great respect, the responsible lady for the legal department at ISRO at that time put it in writing. And so our clients were a bit concerned, how can we do this? So I gave a counter, so to say, an opinion saying that this cannot be. It may be a sovereign sort of a contract, it was not. And it is signed in the name of the president, but it definitely is not at all protected by any immunity that is a sovereign immunity. The only exception known to law for such things is if the president is himself sitting in the satellite and is launched it out to space, then it is a sovereign contract. And I wrote it down, which turned up here in the Space Department, and the Secretary of Space luckily had a very good sense of humor. Normally we thought that we are going to lose all these contracts when we sent such an opinion. He summoned us, we went, I explained, and he says, yes, I like this. From now on, all our contracts will be under French law. And that is how we got over this sort of a situation, which I'm sure my friend would recall when he was there in Paris. Also, then the several launches that have taken place are all under French law. Because after all, you are a passenger on a bus. You can't say on the DTC bus, I will apply my law. It cannot be. So then this is just one of the instances which we have to deal with the other way around. Now, when we have arbitrations, which is a very important part of the any international contract, when you are trying to settle a dispute, applicable laws was one. The other is, of course, the venues and the system that you are going to apply. I personally used to believe, and I still do, that Indian law should be used if you are performing in India, which needs a lot of convincing to the Europeans that no, Indian law will still safeguard a lot of your interests, which they do, I agree. But lately we are having a lot of difficulties in terms of Section 34s or the delays and procedural delays which we keep encountering in the, with great respect to the High Court, that is where we generally all end up, and sometimes to the Supreme Court. But here I must, of course we will come to that as a, from this point. You see, there was another instance like this which is quite hilarious. Thanks to COVID, we were not actually meeting face to face, but we were sitting perhaps in Nice or somewhere and arguing with the judge over here. And the first question I was asked, how, Section 34 incidentally, how long will you take? So I said about 20 minutes. So there was total silence on the Indian side, including the judge. He said, oh, that's good. I said to the judge that you seem to know the case. The other side was not even, which was incidentally the government, it was not even present, except one junior. So they said, no, I did my submission, which was very quick. It was essentially in writing, and which is what you learn when you are in the civil law systems. You go on exchanging your written documents between A and B, and then the judge fixes a date when we all agree that the submissions are over. Then you get a chance to make your arguments, which is on a fixed date for about 15 to 20 minutes each side at the most. So that was the thing with which I said. And I was pleasantly surprised that the judge here in the Delhi High Court insisted on the other side to conclude. And the government was not ready. We had some people with big stripes, solicitor generals and what have you, which was already frightening. But no, we won the case, Section 34, in one day. I think I nearly created some kind of a big revolution. But when you go to enforcing it, that has taken me 5 years already in the same court. Now, why did it take? Because I think the government was trying to get their revenge that I won a few millions of euros. So we took it in the right spirit and waited our turn, and the judge's good mood, and won the case, and everybody is happy. These are the little things which I wish to draw attention to, because this is such a huge topic where we really need to bring about reforms. And one very important subject which I shared with Mr. Singhi and his colleagues when we've met is in India we have 90% of the caseload is because of a government or a governmental organization which is before the courts and going in appeals and things like that. Now, this is the same with the tax department. I heard our colleague talking about the ITAT and what is going on and why shouldn't we have some reform and mediation. I am fully for it, but I wish to show you what is it that they do in, say, France or Germany or Holland, or which are civil law countries, and also in the UK, which is Anglo-Saxon. The one thing which hits us most is that either by law, which is by statute in France and these countries, the department or the government is not authorized to go in appeal. So the fellow, if it's a taxpayer, the decision is against him or for him, that decision is enforced. The maximum you can ask for is a gracious jurisdiction to the departmental head and say, please give me 5 installments to pay or 10, don't send me to jail, I will pay up, and so on and so forth. And that is invariably granted. But no such thing as the government of India or its department not taking its own call and decisions and going on and on and on. And with great respect, Madam, I see these sort of cases proliferating in the courts, and both the lawyers and the judges are merrily giving time to both sides. What for? I think I take the blame. In my own fraternity, we have to also change. I hope my colleagues and friends will agree that and the judges who are also part of our own fraternity at the end of the day, we should also change and say, hey, let's change the system in the sense that it doesn't cost much. All that you have to say is, like I gave you an example, the judge said 20 minutes, he accepted mine, and told the other side, government, carry on with your argument. Now, if a judge were to say that 10 times a day in the Delhi High Court, I think 50,000 cases will be finished in a matter of days. Now, in the income tax, you see, is something where I find as a concrete proposal which one could make once again to the government of India in its present dispensation, I'm sure they will agree to it, that there are so many steps. There is a commissioner, then there is a CIT, then there is ITAT, and maybe not the Delhi High Court or High Courts, then eventually the Supreme Court. And then if after Supreme Court you can again start a negotiation. Now, what for? It's a great-grandson who will eventually be fighting the case. Why don't we, as a strong recommendation, remove the CIT, perhaps remove the ITAT, and go straight to the High Court, or go only to the ITAT and close it. This is what is done in most countries outside. Having said all that, I would love to take any questions if you have, and will be more than happy to make further suggestions in great details to achieve our desired common goals. Thank you very much.
Thank you, sir. So, in short, I think what you said was to get a judgment is easier than to execute it. And I think we all must agree to it. To get an execution done is difficult. And just sharing a small thing, as far as consumer court is also concerned, judgments we pass day in and day out. But you see, to get the people to make them pay the money is the most difficult task. So I think we all agree to it. And thank you, sir, for your words. And now, may I pass it on to Mr. Syed?
Thank you very much, Justice Sangeeta Dingraji. My distinguished panelists, I would also be a little anecdotal while commenting on some of the topics which are mentioned. It's a very huge subject, bridging borders, comparative perspectives on Indian and foreign thing. But I must tell you that in my previous capacity, last capacity, in the government of India as the secretary dealing with the consular matters, I was dealing with all kinds of consular matters, including extraditions. Then earlier in my postings as ambassador to Saudi Arabia and many other places which were public dealing, which means a large number of Indians there. So we come across various kinds of litigations and situations where legal opinion is sought by the Indian companies if they are doing business there, or by the Indians who are living there. So that's where I find that the initiative taken by S.K.Singhi group to form the Lexits is indeed praiseworthy, because if you can navigate through a situation where you don't have to go through a lengthy litigation, it is something of a most ideal scenario. I'll give you an example. See, Saudi Arabia, it is the 2/3 the size of India. The legal process there is very complex. It is not what we follow the English law or any other common laws. So one needs to be firstly very perfect in that law, that is mostly based on Sharia law, and then it is primarily the judgments and the entire hearings are done in Arabic. So this is where our companies and our individuals face difficulty, because they don't understand, and sometimes the judge may ask a question, they would appoint an interpreter, the interpreter may not interpret properly, and this guy nods his head, and that's the end of his case, because the judgment is given. Now also the problem what we have seen, very basic minor thing, is that if you do not know the culture of a country, then you cannot do proper business, then you cannot do proper legal guidance in that country. Again, going back to the same country, it is there are distinct divisions, regions there. So generally what happens is the local companies have a tendency to sign a contract for the entire country. So our companies which are looking for opportunities will go and sign a contract, and many of these Middle East companies, they would use international companies like stars on their shoulders. That means, okay, I have 21 companies international representing, 30 companies representing, but without having the wherewithal to actually manage or promote them. So what happens is, after signing the contract in a couple of months, the companies which has signed, let's say an Indian company, realizes that they are stuck. They are stuck because they have signed a complete countrywide agreement. They cannot go out of it because there is a limiting clause which they haven't seen, that they cannot go to any other agent without the formally abrogation of this. So this is where we face a lot of challenges. We also face a lot of challenges because of lack of recognition of Indian laws in some of these countries abroad. For example, we have distinct laws protecting women in India, particularly newly wedded in the first 7 years and others. They would simply say, this is not India, we go by the law of that country. So you are stuck with a very peculiar situation. How would you navigate? Of course, part of these problems are government to government, because you would need perhaps a channel where mutual recognition of laws would be a requirement. We are doing it with many countries, but this is something we need to be abreast of. Then, as former Foreign Secretary and my senior colleague, Mr. Harsh Singla, had mentioned about certain international disputes which come up. While I was the secretary, we came up with a very peculiar situation where a friendly country, or a so-called friendly country, sent us a formal communication claiming part of our exclusive economic zone, part of our flight area, and then said when the British decided this, or whatever the situation, they were not fair to us, so now we feel that we claim part of your flight area. So we were taken aback, because this kind of a situation had never happened like that. So I think in your legal fraternity, one has to be prepared for any kind of eventuality, any kind of situations. So I think this kind of forum which you have come up is indeed extremely useful. One of the topics was how do we compare our investment climate to other countries thing. My comment on that is that by and large, of course, we are moving very steadily, but there are a few grounds where I think we need to further improve. Of course, you remember there used to be this World Bank ranking which stopped, I think, in 2021. At the last count, we were 63. I don't know what would have been our count if that parameter had continued. And the World Bank had also started rating our states. So the advantage then was that each state, there was a competition started among the states in India to attract foreign investments. Now, there are certain states in India which actually carry the investment load, be it Gujarat, be it Maharashtra or Telangana or Tamil Nadu or Karnataka. But there are others also, many of them are catching up. In fact, I belong to Telangana, and there is one peculiar rule which they have come up there. They have put the onus on the bureaucrats there. If within 15 days they don't clear the approval for a foreign investment, actually per day 1,000 rupees is deducted from the salary of the bureaucrat. So this has never happened in our history in India there, that okay, you delay a file for 1 day, 1,000 rupees. So if he delays 10 files, that means whole of his salary goes. So I think some innovative measures like this would help. And also, I think Mr. Shingla also cited about an incident where Maldives backed off a contract, given to an Indian company. But I cite a state government, without naming it, in South India, where because of a change in government, they really backed off from international contracts. And the same state government, when I was ambassador in Saudi Arabia, sent a delegation, and expectedly during the interaction, the Saudi businessman said, your previous government had cancelled what your previous government had given. So how do we then feel confident that sovereign guarantees are not met? So some of these things are there, but I think overall, if you look at it, we are in a good ground. But the approaches what you are bringing about is certainly indeed which should be inclusive, because not just the legal fraternity, but people from different backgrounds, because there are different perspectives which come in. As far as the AI is concerned, we know all that we have been beneficiaries of AI. In the morning we have discussed exclusively, so I don't want to dwell on that, but I would just say that different countries also view it differently. For example, United States have a decentralized approach. The UK has prioritized on AI safety. They had done this first AI summit, AI safety summit. China is more protective and more centralized. Europe is a more proactive. So I think we should have a balance of both. We cannot be too strict in enforcing legislation. That will kill the innovation which would come in. At the same time, we have to be prepared because this is an uncharted territory. We don't know what will come up in future. Thank you, ma'am.
Thank you, sir. I think what you hinted was that we must fix accountability. And that was a good idea when you said that 1,000 rupees penalty should be imposed, because even in the daily work you find that the files are retained by the persons, and then you can't ask them only except that you plead with them, why don't you send the file? So I think these ideas should work. Anyway, now coming to, please sir, yeah, Mr. Daksh Gandhi. Yes sir, please.
Thank you very much for the chair, and thank S.K.Singhi and Singhi and partners for providing me the opportunity to discuss the cross-border litigation and how to deal effectively. Almost all my previous speakers, and they were talking about how difficult it is when you talk about the cross-border litigation. One is the difference in procedural laws. Second is substantive law itself. Because we have three systems in the whole world. One is common law system, and second is a continental system. And third is a mixed system where the religion, he was talking about the Sharia law, that is also added there. So our lens, when you fit in for giving legal advice, don't fit a single lens. It is progressive. You put a progressive lens when you just wait for, what is the opinion that is required. Another important thing I have noticed, Mr. Sringla was referring about the child foster care cases. One such case, if I anecdotally refer, that was a case about a mother deprived of a child, that is Norway, in 2012. And I was involved in that. We went there, the court system was completely different. Where, they go by whatever the executive statement, the executive department statement, whatever they say in the court, especially the social service organization, they take so much whatever they say about it. And finally, to get the benefit out of it, and we have to just intervene diplomatically to talk to the other side. And second important case is that's why I know what I want to insist is the executive support should always be there in certain of the litigations, most of the litigations today. Because when we deal with that, we don't really recognize, because we just look enormously on the statute law and whatever the decisional materials that you have it. That's not sufficient. It is only for the Anglo-Saxon system, especially the common law system. And the common law system also varies. Say, for example, another case I would refer, that I was in fact involved in that. One is, Shingla knows about this case, it is about the permanent mission of India versus United States. Where the tax exemption we wanted, because it is a diplomatic premises, and that should be exempted. But if you see the precedent of the US courts, they say that it is not your entire structure that is exempted. It is only the chancery is there. Up to that it will be exempted. And you have residences also that will not be exempted. So even in the application of doctrine, that whether it is a Jessonius, or it is a commercial act, or a sovereign act, as commercial function or a sovereign function, every state has a different approach to that. It is not that the common law approach we are concerned with that will be applicable. Then some area where you can find that the continental flavor is added there. Where comes, very importantly, that the time-specific argumentation that is permitted in the court. World court permits only 45 minutes. Rest of the things would be only a written memorial. Anytime, you can give a memorial. Other side, you can just give a note. And they will also submit another memorial like that. And a similar way, if you go to the United States district courts, even at the time, it is only 45 minutes. Even today it is true. It is 45 minutes is given, that's all. And beyond that, you are not allowed to argue any case, submit any matter for that matter. But you can always meet the judge along with the other opposite counsel and you present submissions there. So yet another important matter is there, the execution. And we talked about that. And the execution, if you see that there are silent way, silently you can kill the execution. That's what they were referring about that. If it is an unpleasant decision, don't execute it, don't enforce it. So there are several mechanisms there. But here, what normally we fail to just note that there are quite a number of international agreements. One such agreement he was referring about that. It may be bilateral, trilateral, plurilateral agreements. Sometimes it will be an agreement that comes out of UNIDROIT. Agreements that may comes out of, the private international law settings. So all these things, what we have been doing is, we will not look into it. Because this in fact gives you a kind of a bridge between your system and other system. Because those states, they are party to that, if they are party to that, and they have to accept whatever you say on that. So you have to see that your legislation, whether it is attuned with the private international law reference there you are making. Whether the other party, they also under the private international law agreements. Then bridging is made. Apart from that, quite a number of, the judicial assistance agreements are there. And he was referring about that previously. It was like, taking of evidence and taking of, this whatever the statements that can be recorded. And today it can be recorded, e-recording is permitted, e-submission is permitted. So the technology permits you to just, get into almost all the nitty-gritty of your litigational issues. So this, we forget. We just sit there, you just, you are attuned with only the statute law. That's all. But that approach is wrong, because with that you will not be able to give any idea about what will be the future of the litigation. So the point is, when you want really to give an opinion, not only refer your own system, you refer other system, try to understand what the other system is, what is the rule of evidence is, and what the other system permits in matters of argumentation. Then at the same time, when a decision is there, when it needs to be enforced, there is a stipulated time. So all these things need to be looked into that. So if you have to do it, and whatever the consultation that happens in the platform, that should be vetted not by a single lawyer. So the people who specialize in 2-3 things, they have to run through this thing. And you have to run through this. And they have to see. And they vet. Then only, you will be able to just give the prognosis. What will happen in that case? Otherwise, it is highly difficult. I think with this, I end my intervention. Thank you.
Thank you, sir. Keeping in time, I'll request Sumitra ji to.
Thank you, Honorable Madam Justice. Well, everyone, समग्र भारत राष्ट्र को विकसित भारत बनाने में माननीय प्रधानमंत्री जी ने वसुधैव कुटुंबकम का नारा बुलंद किया. What was the reason? One primary reason is that when we adopted our constitution, we did not lose the values that were universal in nature. Sarvajan Hitaya, Sarvajan Sukhaya. Even Beti Bachao, Beti Padhao has got a value embedded in the Indian constitution, right to equality, but also to raise the people who were not been able to gain gender equity. Now, when the topic comes to bridging the barriers between the Indian and the foreign law, I dated back to my school time when my dad was posted in Myanmar. So one fine morning, we all woke up and my father had to rush to office because Myanmar is governed by Myanmar administration and the rules of Myanmar. So my mom told me that an officer, we call it as PBO or post below officer rank in the Indian Army or the defense, he had been stabbed to death. The early morning, 7 a.m. Now, the Myanmar administration, he was stabbed, an Indian officer was stabbed to death by a resident of Tamu and the encompassing Myanmar district. So, which rule is to be governed in this criminal act? Is there any statute which governs this in the International Criminal Court? Nobody knew this. So, how to sort this matter? Who killed that man? So, a case was registered and everybody was held in a spectacle of awe. Will the Indian government, will the Indian judiciary handle this system? Will this case be handed over to the Indian police at the barriers, at the fences of the country, or the Tamu government or the districts adjoining the Myanmar city are going to do this one? Later on, as times moved on, I went to Dubai and I was having a chewing gum in the metro. So people told me, no, you will be booked. I go to Indonesia at one place and people said, no, you cannot be clad in this dress, you have to wear an abaya. I said, no, I'm a Hindu girl. Why will I do that? They said, ma'am, this is the rule of law here. I said, wherever I go, I am governed by the IPC. They said, no, ma'am. I go to London and there I find people, I met people very, very colonial in nature. They don't want to move ahead in times of the pages of history. And as Alfred Linton says, that the cultures and the cross cultures are the assimilation of subcultures which are passed in different subsets from one generation to the other. So 200 years back, the colonial rule that existed in England is still existing in some forms. They do not accept any other law. If I, a Hindu girl, an Indian national, go to England, I'm sorry, Vijay Phadke sir is an international lawyer, sir will agree with me. Yeah. Yes. So they tell me, no ma'am, you are governed by the laws in England. I say, okay, but then what about the cities adjoining England and the Wales? I travel to Ireland, there they say, no ma'am, we are governed by the Irish rules, we are not governed by the rules in England and the Wales. So things happened like this. I went to Australia and Melbourne and I went to a very far away place. There was no habitation. They said, ma'am, do whatever you want to do. There is no law here. I went to Chushul where my father was posted. That is an area adjoining China. So this particular mountain belongs to India and this particular mountain belongs to China. And there is this passway which is a no man's land. What happens if there is a criminal incident? Who is going to govern this? So I dated back to the Indian courts where they refer to the international conventions as external, because ma'am would agree with me that the Supreme Court in Vishakha versus state of Rajasthan, they took to international conventions to frame the laws. So what made it the Indian government or the judiciary to look up to the international conventions? Primarily because all of us are humans and the human values are quite universal as stated in the section 2D of the Human Rights Act. Now, there is another case law governed in the Indian National Legal Services versus Union of India where the court said that if the parliament can make any legislation, but whenever it comes in conflict with the domestic law and the international law, we are going to stick to the domestic law. Now there is another case law, case of Krishna Sharma versus State of West Bengal, wherein the Calcutta High Court said, so wherever there is a conflict between the domestic law and the international law, there should be a consensus between the domestic law and the international law. So which is that statute governing both the statutes, both the domestic law and the international law, and where is that going to bring a consensus between the people of different religions and different nationalities? So I have a friend in Nigeria. He says he's a businessman, a very smart businessman running several businesses. He told me, I'm going to do a business with you. Let's sign an MOU between both of us, and that will be to facilitate the supply of marijuana. I said, what? Marijuana in India? I mean, he said, yes. He said, and I told him, what is it that facilitates to sign an MOU between two individuals? He said, no, there is a treaty which governs this. Now, where is this treaty mentioned? But they said that all businesses in Nigeria and other parts of South Africa are governed by those treaties. So, when Bharatiya Nyaya Samhita, when Bharatiya Sakshi Adhiniyam, and when BNSS came into being, only one thing was upheld, and that is one thing that governs the glory of the nation, Satyameva Jayate, which is the mantra for the Vishwa Vasudha Ek Kutum in making our country a Viksit Bharat Rashtra. Okay, fine. International criminal courts have their own statutes. International Court of Justice has their own statutes, and Indian courts have got their own laws and governance. If there is a criminal offense in our country, why would ICJ interfere into that? In one such instances, ICJ said that let the Indian judiciary decide it. What they decide, we are going to put a stamp and seal on that. So, well, everyone, what we would like to talk about in bridging the barriers between Indian and foreign laws is first to bridge the barriers of the human values. Because humanity is one, laws are for us, we are not for the laws. If we become substitutes only for the laws, we become stones. Gandhiji once said that self-reliance comes when every village is potent in being self-reliant. That is the gospel of Atmanirbhar Bharat. Today, when National Education Policy 2020 talks about building foreign campuses in India, which is the rule governing both the countries? Is there, I do not think, in the Right to Education Act of 2009, we do not have a separate clause which says that foreign universities should be built up in India. So there is no law for this. So what is the fact of the matter is that when good things come on our way, laws are framed accordingly. We can bridge the barriers only when the human values are put into consideration. As Dr. Gandhi talked about that woman regarding fostering the childcare, there was a very good movie on this featuring Rani Mukherjee. I do not think if it's the same thing. Yes. So in that movie, what was told was that it is the values of the mother. The child should recognize the mother and not the wealth of the father, which will determine in a foreign country, which will relate to, it was not a case of adoption. Now, I'll give you one instance because everybody here is a very illustrious person, I being the least experienced, but then there is something anecdotal with me. So there is a woman, a Muslim woman, who goes to Ireland. She marries a Pakistani and goes to China for work. Now, she starts her business and she has a business with India. And they have a business of selling dolls. They have a business of selling dolls and the dolls are very, very pricey. Now, something happens personally with her and she says that I'm personally not competent to do this business and on my behalf, my sister will be the substitute. So, there was no treaty between the two countries. There was no treaty or MOU between the two people. So, nothing happened. And then there was a conflict with the domestic law, international law, and then treaties which govern the businesses. So, what should be in place? Well, everyone, what matters here is, I'll stick to what I started with. It is the values first. Personal things can be sorted. Domestic laws have to be submitted first, and then comes the international law. And we being the citizens of our country, we have to abide by the laws and regulations of our country. For last but not the least, I would like to talk about that there have been many questions talking about international law in every continent of the world. And when it comes to India, there is only one question that people talk about, and that is the human resources. Have we been able to create a statute to how to handle a very skilled human resource? Now that people are substituting human resources with artificial intelligence. For one thing is that businesses and crimes have got no borders. So where do we bridge the barriers? Submitted, ma'am.
Thank you, ma'am. As far as legal barriers are concerned, you see, jurisdiction is a very important point, even coming to national and international laws. Even in India, you see, the new now criminal law at least talks about the zero FIR, which was not there, because we couldn't sort it out all these years, which police station would have the jurisdiction. So now it is in the law that there would be a zero FIR, and all right, then it would go to the whichever police station it would relate to. So with this, we wind up, and thank you, Singhi and family, for inviting us, and it has been a very fruitful discussion, and of course, the recommendations we hope to see later in the day. Thank you.
Thank you very much. That was an enlightening discussion that we came across, and thank you very much for sharing your thoughts, views and ideas with all of us. It was indeed a pleasure to listen to such eminent personalities sitting here on the dais with all of us. Ladies and gentlemen, before we wind up, we have tokens of respect for each of our speakers today who joined us in this discussion. To present these mementos, may I please invite Justice Rajesh Tandon to please join us on the stage and present these mementos. हम निवेदन करना चाहेंगे सर कि आप प्लीज़ इन मोमेंटोस को प्रेजेंट करने की कृपा करें. सबसे पहले मॉडरेटर के साथ शुरुआत करेंगे. Honorable Justice Dr. Sangeeta Dhingra Sehgal ji, followed by the other panelists. Shri Vijay Phadke, Shri Harshvardhan Shringla ji, Shri Yusuf Said ji, Dr. Sumitra Singh, Dr. M. Gandhi, सभी को सम्मानित करना चाहेंगे और धन्यवाद करना चाहेंगे. So beginning with the moderator, Honorable Justice Dr. Sangeeta Dhingra Sehgal, President, Delhi State Consumer Disputes Redressal Commission. जोरदार तालियां सभी की ओर से. May I please now request the moderator and Justice Tandon to present the tokens of appreciation for each of our panelists, beginning with Shri Vijay M. Phadke, international lawyer who's present here with us, who shared his thoughts with all of us today and joined us on this panel. Sabhi ki or se abhinandan, dhanyawad. Shri Harshvardhan Shringla ji, thank you very much, former Foreign Secretary, Government of India. बहुत बहुत धन्यवाद, सभी को आभार. Thank you to each of our panelists, Mr. Asif Saeed, former Foreign Secretary, Government of India. We thank Dr. Sumitra Singh and Dr. M. Gandhi. Ladies and gentlemen, getting the mementos quickly. And after this, we will be, delaying the second panel and taking it to post-lunch. Dr. Sumitra. Thank you very much. Thank you very much, ladies and gentlemen, and we'll have a group picture after this, and post that all of us will proceed for lunch. Originally, we were supposed to have the second panel before lunch, but I think we are facing paucity of time, and since we are pressed for time, we would like to shift it to post-lunch and quickly come back after lunch. तो इसके बाद हम सभी लोग downstairs, we'll all gather downstairs for lunch and then reassemble for the further discussions, the panels that we have planned. I'm sure they're going to be as enlightening as this one. We have illustrious panelists and speakers who will be joining us in subsequent discussions as well. May we request everyone to kindly be back in 40 minutes, please. सभी से निवेदन है कि 40 मिनट के अंदर हम अपना जो अगला सेशन है उसे शुरू करेंगे. सभी से निवेदन कि प्लीज आप समय से लौटें. काइंडली प्लीज रिटर्न इन टाइम एंड फ्रॉम देयर ऑन वी विल बी टेकिंग ऑन द फर्दर सेशंस दैट वी हैव प्लान्ड फॉर द डे. थैंक यू वेरी मच एंड वी इनवाइट यू टू जॉइन अस फॉर लंच. थैंक यू. Requesting everyone to please take your seats. सभी से निवेदन है कि प्लीज अपने अपने स्थान पर बैठे. Ladies and gentlemen, welcome back after the lunch break, and we're hoping to begin soon, and in a couple of minutes we should be beginning with the second panel that we had left behind, and this will be on banking on progress, catalyzing India's $5 trillion economy with inclusive financial justice. I'll be beginning with this panel discussion by inviting the panelists and moderator to take their places on the dais soon. I request everyone to please take your seats. We're beginning with the second panel discussion, Banking on Progress, Catalyzing India's $5 trillion economy with inclusive financial justice. Ladies and gentlemen, please allow me to begin with inviting the panelists on the dais, followed by the moderator. In this panel, we'll be joined by eminent speakers. I would be inviting Mr. Prem Sibal, business mentor and finance professor, to please join us on the dais. Zordar taaliyan Mr. Prem Sibal ji ke liye. We can have a louder applause. We've just had lunch and let's have some energy. Mr. Prem Sibal, business mentor and award-winning finance professor with 43 years overall experience in corporate finance, microfinance, international business, corporate debt, restructuring, credit and risk management, academia, training and consultancy, rich experience. We welcome you, sir, on the dais. आइए आगे बढ़ते हैं और अब मैं इनवाइट करना चाहूँगी डॉक्टर देवेंद्र सिंह, प्रोफेसर Amity Law School. We welcome you on the dais, sir. जोरदार तालियां प्रोफेसर देवेंद्र सिंह जी के लिए. He is a distinguished academic with a rich and diverse background spanning over 25 years in education, research and industry. Joining us, Dr. Devendra Singh, Professor, Amity Law School. We welcome you, sir. बहुत बहुत अभिनंदन. We welcome Mr. Ravi Kishan Thakkar, ex-MD and CEO of UCO Bank. Zordar taaliyan. Mr. Ravi Kishan Thakkar is a distinguished banking professional with extensive experience in the Indian financial sector. He served as the Managing Director and CEO of UCO Bank, where he provided strategic leadership and played a pivotal role in driving the bank's growth and operational excellence. We welcome you, sir. And now may I please invite the moderator, Mr. Pramod Goyal, Director, School of Law and Constitutional Studies, Shobit University. Zordar taaliyan Mr. Pramod Goyal ji ke liye. A distinguished figure in the Uttar Pradesh judiciary, celebrated for his exceptional service and unwavering commitment to justice. With a career spanning over 35 years, he ascended from Munsif, Judicial Magistrate in 1979 to District and Sessions Judge in key districts across Uttar Pradesh. Mr. Goyal has held several crucial positions including Registrar Inspection, Registrar Selection and Appointment and Registrar Confidential at the High Court of Judicature at Allahabad. We welcome you, sir. आइए सभी का अभिनंदन करते हैं और अब निवेदन करना चाहेंगे हमारे पैनल से कि प्लीज यहाँ से deliberations की शुरुआत हो. May I please request the moderator to kindly please begin the proceedings of the session from here.
Good afternoon. Thank you, Lexits and S.K.Singhi and family for providing us this opportunity and to learn and celebrate our journey to $5 trillion economy. In the year 2019, the government of India had mooted the idea of $5 trillion economy. Before we could take off, we faced challenges to human health in the form of pandemic, that is COVID-19. During COVID-19, the concept or the goal of $5 trillion economy by 24-25 required consistent growth, GDP growth of 8 to 9%. But because of this pandemic, it nosedived and we went into negative. But the government did not give up. After pandemic, the economy again bounced back and come to the pre-pandemic level. A $5 trillion economy is not a mathematical expression. It's a goal that has been set by the government, and because of that intervention of the pandemic, we will reach the target of $5 trillion economy by 27, and another $2 trillion will be added in next 2 years, that is by 2027. $5 trillion economy, as I said, is not just a mathematical expression. It's a goal. And to reach it, we have certain components. Banking on progress is one of them. If I say that banking on progress, at its core, aims to leveraging the banking sector to drive growth and financial inclusion. Financial inclusion because in our country, as the RBI says, more than 20% population is unbanked. We have to tap that and hope that this platform will serve and will provide us an opportunity to discuss the ways and means how to further go beyond their goal. Now, I'll request, sir. Sir.
So at the outset, I think it's a golden era. I must really thank the Lexits, Singhi and company partners for, I think, very thoughtful, very transformative idea. Because in my almost 43 years of, we have faced a lot of challenges. Because fortunately, I had that opportunity to do a couple of, I would say, consultancy projects. I think there a reference was made about the ease of doing business. World Bank. I was a part of that. 3 parameters we did. And of course, ranking over a period of time improved as from 134 to 63, 64. 3 parameters were given to us: starting a business, protecting minority interest, and third was, I would say, how do we make our, contracts, I would say, workable, because our ranking was very poor, to be very frank. That affected our overall ranking. Fortunately, at that time, this IBC was not there, insolvency, and therefore recovery was a big issue. So the government has been working on ease of doing business, ease of living, and I would put it that this initiative is the ease of delivery of justice, financially inclusive justice. Fortunately for me, I think I had that really great opportunity to work in 360-degree kind of a situation. I think we had earlier panel of people from the foreign laws, and my first experience, I'll just, because the flavor of the panel discussion is anecdotal, so I'll share certain anecdotes only, which will be a able starting point. When I was sent to our international operation UAE, right, and of course we had largely the Indian community as our client, but yes, there were other people from the UAE nationals also. But only the law at UAE is that, the trade license is given, you have to have a UAE national as a sponsor. And the local person will be putting his equity. And 51% of the share will go to the UAE national. That was a big challenge. Because in case the accounts, some kind of a recovery action has to be taken, you can't proceed against the UAE national. You will have to proceed against our Indian sponsor, They are sponsoring Indian person, Indian who is the promoter or the partnership or whatever it is. So a lot of people from Kerala, Punjab and other places have also gone there. Now, how did we tackle that situation? Because I was sent to the branch manager. So, fortunately for us, our, Consul General and our embassy there did help us in, having a panel of legal advocates on our panel who were familiar with the local language, because the plates, everything has to be in the Arabic, right? And their advocates also, who are in the panel, will also have to be there. Of course, there used to be, our English part, and then they will translate into the Arabic and also prepare beforehand. But the few good things which I could find in the judicial system in UAE, the, judgments were very fast. Within 6 months, mostly, the decisions were taken, and even the RC, execution of recovery, also was relatively easier than what we see here in our country. So a lot to learn from there. But only thing is, as a precaution, we used to, I mean, our advocates, our local, I still remember their names, they used to tell us attachment before judgment against the assets. And not only that, one beautiful thing was that in case their Indian nationals have their assets in India also, we could even attach them also. Okay. And ultimately, that helped us in many ways in, I would say, taking care of the accounts which are, you know, under distress or whatever. Sometimes what has happened is, because a free country, sometimes the dishonest people used to flee the country also. That was also a situation. But luckily, we used to have their passport, and somehow the traceability was done. And somehow we could catch hold of their at least Indian nationals, or maybe Indian assets, or maybe their family members, and we could catch hold of them. That was my first experience. So it was a kind of a collaborative effort with hand-holding, I would say, from our own people in UAE, Embassy, you know, Consul General of India. We are very good terms with them and interact with them. That was my first anecdotal experience, I would say. Secondly, another innings was as head of the corporate debt restructuring empowered group at Mumbai. I was asked to handle the credit monitoring of the bank as a whole, credit portfolio, huge portfolio. Now, fortunately, we created a software whereby all these reports were captured, and we could generate the reports. All critical parameters were there, and we used to put up to the board. We could get exposure, you know, industry-wise also, zone-wise also, region-wise also, size-wise also, rating-wise also. And I'm telling you, the board was so impressed, because after all, when you are taking further exposure, you will be mindful, which zone mein kya chal raha hai, where to lend further, where not to lend further. So that was streamlined. And I think the board and the chairman was so happy, and the ED was so happy. I think they sent my name as a designated executive to the corporate debt empowered, you know, group, where it's a large accounts, very large accounts, credit portfolios. These are consortium accounts or syndicated loans. And I think the problem got accentuated when the proposed reform, the Reserve Bank said, okay, multiple banking is also allowed. Now the question arises, these are the promoters, you are dealing their high profile promoters, and the assets are shared either on pari passu basis, or maybe sometimes if there are financial institutions, you may have a second charge, or in the multiple, you know, again, so these are the sharing of the securities, again, which is a big challenge. And normally in such kind of a situation, I mean, it's very difficult to proceed legally. And always see the since exposures are very large, you know, we cannot have any kind of a sacrifice. Thanks to us, the 2001, you know, the meltdown which took place, the corporate debt recovery scheme, CDR mechanism was evolved under the aegis of Reserve Bank of India, RBI. So that is the regulator sanction. Under that, the projects or the large loan accounts which could be revived, of course, eligibility criteria they have to fulfill. Means they have been impacted, they have come under stress because of the external factors largely. Or maybe some kind of a, at time technology, but they are viable. In the long run, they are viable. If you are putting an additional equity, or maybe some additional lending also, they can be turned around. So that kind of a situation was there. And of course, the other thing was that the promoter has been very diligent, he's committed, he's honest, and is willing to put in more equity for the revival plan. Accordingly, the revival plan was worked out, and the, you know, approval was done in a very democratic way. 75% of the value by value banks, and 60% by the number. Once these banks approve it, the proposal will be put through. Revival plan will be prepared, and the revised projections will be, you know, accepted. That will be obviously lower because the economy has now affected them, and they will be given additional time. Maybe the rate of interest will be lowered, or maybe they will get additional time. But the other conditions are that there will be escrow account. Either all these cash flows will be captured in the escrow account with the lead bank only. On the permission of the lead bank only, the project related expenses, salaries, and maybe electrical expenses, electricity expenses will be allowed. And of course, the meetings used to, every 2 months, the meetings used to take place, how the revival plan is working. At times it used to be quarterly also. But I think we used to see that whether the timelines are being met. At times, the debt has become unsustainable, but yes, it is viable. So some kind of a capital restructuring also became necessary. Meaning that a part of the debt will be converted into equity, of course. Once it is revived, then the banks will be entitled to some kind of an upside. And maybe zero coupon bonds were also issued. So all this capital restructuring was also done, because if the viability is showed and the project has been impacted largely by the external factors, and I'm saying whatever sacrifice has been made in the intervening period, the bank have a right to recompulse. I mean, once the account has become healthy, they are bound to pay back. See, whatever the, it used to be on an accrual basis, shadow account used to be maintained. And the under that kind of a agreement with the corporates and also all the banks, in the ratio of pari passu charge or pari passu basis, the recovery was shared, and also the right of recompulse was shared. So that is how the system worked. Unfortunately, some of the corporates started taking undue advantage of it. That's how the scheme could not work further. The previous governor, Raghuram Rajan, thought, because see, the burden became on the banks. They knew that now the psychology of the borrower is that the bank is more interested in save the account to becoming NPA. And also, see, they took advantage of it. And they did not honor their commitments, meaning the infusion of equity was, not coming the way it used to be, and some kind of slackening happened. So that is how the restructuring scheme was continued. And thereafter, of course, it was left to the bank's board itself. But it did not have the RBI, kind of a sanction. On a case-to-case basis, on the merits of the case, boards can approve the restructuring plan, reschedulement plan, without going for a, court action. Because ultimately it's a lose-lose game. When you go to the court will drag on. Borrower will be happy, now see they got time. And the asset stripping used to take place. By the time you get, RC or maybe final judgment, assets are more or less not available. Even though banks take a precaution that, we are having a judgment before, attachment before the judgment. But still, you have to get them insured also. And you have to put some kind of a security guards also to those assets. Because ultimately they are the bank security, lent by bank only. So these are the hassles which the bank had to face. See, that was, sir, my second kind of a exposure which I would like to share. Third thing which I got was when I was sent as the chairman of our subsidiary bank at Nainital, right? That was a different ball game altogether. When I saw, first of all, of course, the language was there, mostly it was used Hindi. I am quite familiar with Hindi, so that was not a big problem for me. And I had a very good team also. And also we had some kind of, very active participation from other board members, maybe Reserve Bank nominee there, Government of India nominee there, state government nominee there. So a lot of collaborative approach was there, how to tackle the situation. So that was the benefit. But the issue was that the number of accounts were very large, but the size, ticket size was small. Meaning there will be either agriculture accounts, recovery accounts, agriculture accounts, or maybe the small borrowers account, weaker section. So it's not workable to proceed, legally or maybe take action against them. At the same time, the money has to be got back. You cannot write off. So I thought about it, how to deal with this situation, because it was impacting our profitability, it was affecting our asset quality. How do I tackle? Fortunately, as a bank, a prominent bank, we were part of the district level committee. Every quarter there used to be district level, and they have a district credit plan to fulfill. District magistrate appraisal depends upon the credit plan. How do you fulfill? Where do you reach? And I saw an opportunity there. I said, sir, we are there in the business of lending, but you have to help us. Two things I want. See, whatever your various schemes are there, KYC scheme or whatever scheme, agriculture ki scheme hai, ya handloom ki scheme hai, according to the area specific or a tourism scheme, we would definitely lend. But my area manager, my lead will at least have a preliminary examination. They will conduct some kind of a screening. Which are the type of borrowers which we can lend to? How much they are serious? how much they know about it, because ऐसा नहीं कि application भर के आपके पास आ गया और आपने हमको forward कर दिया और क्या आपने target पूरे नहीं किए. This is not acceptable, right? Otherwise you will say so many rejection and you will put, criticize us. No, we want to sanction as many as possible, but on a merit basis. We will evaluate. We will say, okay, you have sent us 50 applications, out of which maybe 35 or 40 we have found it okay to deal with. उसमें 30 होते हैं, कितनी होती हैं? So that we will do that. We will fulfill. You have to procure the need-based and eligible borrowers as per the scheme, the good borrowers as far as possible. See, agreed. But at the same time, you have to help us in recovery. How do we do this? Fortunately, in UP and Uttarakhand, for example, there is a Agriculture Recovery Act. ARC होता है, उसके कहते हैं कि अगर RC मिल जाती है ना, तो उसका जो लैंड है वो कुड़की हो सकता है, उसको जेल में भी बेच सकते हैं. We say we are never interested in putting a person behind the bar. Neither we are interested in acquiring the land or selling. We are only interested in recovery. We want to recycle. Last point. Last point. I just finished. Sorry, I just closed. Finally, sir, the recovery campaign were done with their assistance, ADM revenue. And last of four, so I'll just close it in the last 1 minute. See, DRT, the Asset Recovery Branch, I was where all the loan accounts were aggregated. That was a very tough kind of a situation where we had to largely, based on the OTS, one-time settlement, wherever the assets were there, and also, again, attachment before judgment, even guarantors also, and sometimes we had to use the detective also. Thank you, sir.
Thank you very much, sir, for the kind words. Actually, the role of banks has shifted from just facilitating transactions to ensure financial justice. This concept has literally reformed the role of the banks. They have to reach out to the people who are underbanked or unbanked, so that they may have access to the financial services. When they get the access to the financial services, they may reach on the benefits of the growth. With these words, I'll request Shri Thakkar to please enlighten us.
Thank you. Thank you, Goel sir. I have been associated with the commercial bank for almost 40 years. And also now I am also associated with the financial sector as a director on some NBFCs. So banks, or whether it's the financial sector, has a big role to play. Whether we are talking about achieving a 5 trillion economy, or we are talking about inclusive growth, the banks have been in the forefront. And especially when I had this exposure of 40 years, initially when everything was totally manual, the interest to be applied, the balances to be tallied, any transaction, so you have to remit the money from one town to another town in a different bank. It may take sometimes weeks together. The systems were such. Then we had this computerization. I think things started changing. You could do anywhere banking, any bank, any branch you go. You could transfer the funds, do your banking, deposit, whatever you wanted to do. And then we had this digital revolution in which you have access to banking facilities 24/7, whether through IMPS, RTGS, UPI, anywhere across the country, 24/7, in whichever bank account, whichever or say the intermediate account you are having in the form of a wallet or anything like that, you can do the banking anywhere. So those boundaries have been totally done away. And you are a customer of any bank and you can transfer fund to any other bank. So it's just become a digital revolution. But over the period, how we have achieved this financial inclusion, I think, is the core question. See, the banks have been doing banking for a long time. They had a lot of, let's say, I would exposure in the rural sector, rural branches. But obviously, our is a big country. It's not possible to cover the entire population physically. So the other intermediaries has to step in, whether it's the fintech companies, or whether now we have small finance banks, or we have these service providers in form of wallets and all that. So to bring all the entire population into the financial sector. A lot has been done already, especially the Jan Dhan accounts. I think it was a game changer. Now every family member, at least every family member has a bank account. That's a big thing. The direct benefit transfer. I think another thing which has changed the scenario, like previously they used to say 1 rupee sent by the government only, say 20 or 25 paisa used to reach the beneficiary. Now it's a direct transfer, there is no middleman. The persons who want by way of a subsidy, by way of a grant, by way of scholarships, whatever form, he is getting it directly. There is no intermediary involved. So 100% amount is being remitted to the beneficiary. So that has been a game changer. But after this financial inclusion, what we have to ensure is financial literacy, and now especially digital literacy. I think we are all hearing about the cyber frauds which are happening nowadays. And if we really see the sum, it is really mind-boggling. And it is penetrating at all levels, whether it's metro towns, urban, rural, anywhere. Because everybody has access to banking everywhere, so you can, the fraud is done on telephone, whatever mode they are, through emails or whichever way it is done. So that financial literacy, and now we call it a digital literacy, has to be now done by all the financial intermediaries in the system, whether it's the banks, whether it's the NBFCs, whether it's the fintechs. I think that has to now percolate if we have to really reap the progress of the digital era. So that is very important. And we all have a big role to play. And the another thing which I would like to, although it may not be a direct thing, but going forward to what Mr. Sibbal has said, is our system, how do we, in the banks, because one of the issues they face is the recovery issues. So we have had a lot of, I think, developments happening in the system. Initially we had the DRT, then we had the SARFAESI Act coming into picture, and now we have the IBC. They have been, in a way, game changers, but there were a lot of issues also, and to the extent they were supposed to benefit the lenders, it did not happen. DRTs, we didn't have the presiding officers, there were no cases were being heard. SARFAESI, again there were issues in the sense that very difficult to take possession, then auction the assets. Although recently Supreme Court had come up with the ruling that the physical possession has to be given by the CGM within a particular period. But still, practically the issues are there. As in the morning session we were talking about, the judgments happen, but execution is an issue. So I think even in, we go by SARFAESI, even if you get a physical possession order, I think even execution becomes, sometimes the police don't cooperate, they don't help you to take the possession, or the borrower creates a problem. So these things are there. Same with IBC. IBC was, I would say, is a game changer, but it is evolving. There have been issues, I think, people going to courts, obtaining stay, then interpretations happening, then the law being amended quite frequently. I think there are concerns on that front, but I think we should be able to make headway in that, and once it stabilizes, I think it's a very good route to ensure that our assets which are not being put in use can be taken over by some new investor or new lender, and they can make it a productive use. And I think that's one of the important things. The productive use of the assets helps us in achieving our objectives. When you talk about trillion economy, whether it's a farming, I think MSME startups, they have been given a very, I think, a due focus on that, or infrastructure projects. So unless we have the funds to finance, and that's another funds start rotating, I think is very essential. So I think that's all I have to say. Thank you.
Thank you, sir. Digital banking, in fact, has emerged as a game changer. And you said, very rightly said, the Pradhan Mantri Jan Dhan Yojana reduced that gap of unbanked people. As of now, 47 crores accounts have been opened in this scheme. And it's a big achievement. I believe that Shri Sibal sir had done something on financial justice. I'll request him to just briefly, please.
The thing is that this particular assignment where I was sent, a lot of people were actually excluded. They were what is called BPL category, BPL, below poverty line, right? And the government had a lot of schemes, centrally sponsored schemes, but the benefit was not reaching. State government schemes were there. Fortunately, this DBT has been a really game changer in the sense, yes, they call JAM, that is Jan Dhan, Aadhaar and mobile, right? Now, see the case of COVID, for example, lot of money has gone to the people, Now, please correct me, I think I understand 52 crore accounts are there, where the banks have done. Earlier, a lot of experiment was done, business correspondent and also use of technology. But once these unbanked areas where it was not workable, I think still we are far away, the technology has bridged that gap. It has helped to include, now mostly all the families are having that account. So I had done a research project also on financial inclusion. Maybe I like to share with the organizers sometime. It was an excellent project. How they came in the financial inclusion has happened over the years. Of course, it is evolving. Still, there could be, and it has helped in reducing our people below the poverty line. Thank you very much.
So I said, India's goal of becoming $5 trillion economy is built on the foundation of sustainable, inclusive, and innovation-driven growth. With these words, I will request Dr. Devendra Singh sir to further elaborate the concept on these lines, please.
Thank you, sir. First of all, how much time I have? 5 minutes, okay. Because why I have asked this? Because if you hand over the mic to an academician, it is very difficult to take off from him. So that's why I asked this specific queries. So first of all, I am also thankful to my seniors who have very nicely elaborated the specific historical background of finance and banking of India, how banking system was developed in India. So let me also take you little bit part of, you can say, modern era of banking, which was, we can say, started in 1991 when the under the government of Narasimhan, when the government of India took very major decision to adopt LPG policy. LPG policy stands for liquid petroleum gas. It is not. It is liberalization, privatization, and globalization, basically. And that was the, you can say, the master stroke for our modern economy in that time. But what was the flaw with that specific policy? They have adopted that particular policy, but without any concrete plan or roadmap, which later on what sir already highlighted, that there was flaw in loan sanctioning, lot of things, lot of NPAs was increased. So that was the, you can say, worried for the government in that time. Then government introspect again and then came up with the Narasimhan committee. This is one of the committee, which is, you can say, the credit goes for this modern banking, what globalization, what economic globalization of our economy. That credit goes to that particular report, which was submitted by the Narasimhan committee. And government of India, majorly recommendation which was recommended by that specific under that particular report, that was taken by the government. And what scenario we have, what sir said, ki earlier what in black and normally I use the word black and white era. What was the black and white area in banking if I am talking about what sir said? Earlier, if I am talking about before, you can say just invention of internet and adopting internet technology in banking, what was the era before that in banking sector that was, which I normally use the black and white era. In that time, the banking was in specific premises, and that era was called bricks and mortar era. Am I right, sir? And after advent of internet technology, that era shifted to bricks to mortar to clicks to mortar. Right now, you can use a simple device, and you can access anything. The word is yours by that device. So that was, you can say, a great achievement. Country like India, if I am talking about why it is a big achievement for the India, the reason being you can see the size of India. We are not European country. We are not the country like our one state UP or something else. Our location, if I am talking about location wise, we are so big country. We have more than 100 crore population. So what development, or we can say what achievement we have already done in terms of economic development, social development, in terms of various development, it is a kind of achievement. And no doubt, the government of India, definitely credit goes to government of India and the people of India. They are very supportive. Whatever ambiguities we have, whatever difficulties we have, but we have tremendously achieved the various targets. It is slowly, but right now you can see, if I am talking about, we are the 5th largest economy in the world. So I think, thank you so much. There are a lot of things which we can discuss. So I will definitely share it. As I have already told, if you simply just hand over mic to an academician, so it is very difficult to take back. So thank you everyone, and I am very thankful to also S.K.Singhi group who have invited me for the event. Thank you so much. Thank you, sir.
When we set a goal for economic development, we need to give up, delay, defend, and deny. The banks and the borrowers both have to leave this attitude. Guess we are already at a time, so let me conclude what we have been discussing. Banking on progress is a transformative concept that connects the banking sector to India's broader economic goals, and hope that this platform will take us further to celebrate the growth and will lead us to $5 trillion economic goal. Thank you so much.
Due to time constraint, I couldn't cover that particular topic which actually assigned to me. Extremely sorry for that.
Thank you very much. That was indeed a wonderful discussion. Can we have a louder applause for the eminent panelists who shared their thoughts with all of us today? Thank you. And to present mementos, tokens of gratitude from our side, may I please invite member of Puducherry Legislative Assembly and a lawyer as well, Shri R.P. Ashok Babu, to please join us on the dais. Ladies and gentlemen, please join hands as we welcome Shri R.P. Ashok Babu, member of Puducherry Legislative Assembly and also a lawyer, who will now be gracing us with his presence on the stage and presenting tokens of respect, mementos to each of our panelists, beginning with Mr. Prem Sibal, Business Mentor and Finance Professor. जोरदार तालियां सभी की ओर से। डॉक्टर देवेंद्र सिंह, प्रोफेसर एमिटी लॉ स्कूल। Please join your hands, ladies and gentlemen, for Dr. Devendra Singh. We thank Mr. Ravi Kishan Thakkar, ex-MD and CEO, UCO Bank. जोरदार तालियां। And we thank the moderator for the session, Mr. Pramod Goyal, Director, School of Law and Constitutional Studies, Shobit University. Thank you, Mr. Goyal, for joining us on the panel and also for being the moderator. And we'll have a group picture after this. We'll have a group picture after this. Thank you very much for that wonderful discussion that we just had. Ladies and gentlemen, we'll be moving on to the third panel discussion, the subject for which is sustainable justice, aligning ESG principles with an inclusive legal framework. So we just heard on the subject of banking on progress, and now we move on to sustainable justice, aligning the ESG principles, with an inclusive legal framework. And may I please begin by inviting the panelists to kindly please join us on the stage. Ladies and gentlemen, I invite Dr. Bhaskar Chatterjee, former Secretary, Government of India, to please join us on the dais. Zordar तालियों के साथ अभिनंदन Dr. Bhaskar Chatterjee, a distinguished former Secretary and former Director General and CEO of the Indian Institute of Corporate Affairs. Renowned as the father of corporate social responsibility in India, Dr. Chatterjee was instrumental in the inclusion of Section 135 in the Companies Act 2013 and in framing the CSR guidelines for public sector enterprises in 2010. We welcome you on the panel, sir. May I please invite Mr. Hargovind Sachdev, Director, Innovace Advisor, ex-GM, State Bank of India. With over 40 years of expertise in the banking and finance sector, Mr. Sachdev is an accomplished leader, currently serving as ED at Singhi Capital Finance, a prominent non-banking financial company specializing in tailored financial solutions for corporates and individuals. We welcome you, sir. We invite Professor S.K. Bose, School of Law, Manav Rachna University, Director, Center for Legislative Studies and Research. He is a distinguished academician and legal expert currently serving as Professor of Law at the School of Law, Manav Rachna University, with over 29 years of experience in teaching, research and practice. He has made significant contributions to legal education. We welcome on stage Dr. S.K. Gupta. He has about 43 years of corporate experience in leadership positions in domains of finance, valuation, etc. He is currently the CEO of ICMAI, Social Auditors Organization. He has written over 350 articles and research papers. A big round of applause as we welcome Dr. S.K. Gupta on the panel. And now I invite the moderator for the session, Justice Rajesh Tandon, former Judge, High Court of Uttarakhand. Zordar तालियों के साथ अभिनंदन. A distinguished legal luminary who served as a judge of the High Court of Uttarakhand, with a career marked by integrity, dedication and profound legal acumen, Justice Tandon has contributed significantly to the Indian judicial system. We welcome you on the panel. जोरदार तालियां हमारे सभी पैनलिस्ट के लिए.
Yes, I am thankful to the seminar organized by Mr. Singhi. This seminar really has learning a lot. Learning in the sense that different topics he as Mr. Singhi has chosen from morning to end. And this topic is really a constitutional topic, that is ESG, means environmental, social, global environment. And what is ESG? That has not been explained by Mr. Singhi, but what I interpret it as an environmental factor, social factor, and that is a global sustainable development. If we look to the preamble of the Constitution, the preamble of the Constitution consists of all these things, that is the three things, that is environmental factor, social factor, and the globalization also. Because three things have been defined under the preamble, and for that purpose I demonstrate and I divide the three things borrowing from the preamble. That is, one thing is the constitutional protections given under the equality of state, that is also preamble, assuring the dignity of the individual. Another is constitutional protection relating to liberty of thought. And third is relating to preamble, that is constitution, that is justice, social and environmental, and equality of states. These are the three things. Now, when I confine to number one, that is constitutional protection given dignity of the individual, I immediately come down to the dignity that has been defined under the preamble, that is also a protection under the Protection of Human Rights Act 1993. Section 2D defines dignity. What is the dignity? Everybody has dignity in the modern world. Our Constitution preamble also starts from dignity. Article 21 also talks about dignity, and therefore dignity is everything nowadays. A man has dignity, and for the dignity purpose, he requires three things, that is good environment, good living, and good clothing. That has been defined under the good dignity, and the Supreme Court in various judgments, that is either take down the Khadak Singh judgment, Kapila Hingorani, all these judgments, the Supreme Court has taken out the Universal Declaration of Human Rights of 1948, and the Supreme Court has said that these things are proper, and that's for a proper dignity of a man, three things are required, that is proper living, proper environment, and proper food. These three things are for the human rights, and that is the preamble of the Constitution, that is equality, status, dignity, and equal protection of the life of the person. That is also borrowed from Article 21 of the Constitution of India. If we take out the environmental factor, that has also been defined under Article 48A of the Constitution of India, which talks about the environmental factor. One has dignity to live in a proper environment. That is the crux of the Constitution of India. That is the crux of the preamble of the Constitution of India. I remember one instance of the environment where in Nainital, the horses were going on from Tallital to Nainital. They were making large number of dirt. Somebody has come up in writ petition, that is, one Ajay Singh Rawat has filed a writ petition where he has alleged that the horses are giving bad environment, and bad environment is causing such that the people are unable to walk from one street to another street. Then the Supreme Court has interfered and has stated that the Nainital, a beautiful city, the horses are destroying the passers-by and they are unable to move that, and therefore the Supreme Court has stopped the going of the horses. These are the effect of environment, and environment is a preamble of the Constitution of India, and therefore one has to be very that the environment and the social and equity, all these things are preamble of the Constitution, and one has not to play with the nature of that the nature is the primary thing. You must have heard the climate change that is in the Kedarnath in 2013. What has happened, that all the cars were destroyed, all the persons have gone in the hill area, nobody was known, and these are the climate change. One should not play with the environment. These are the things, cutting up the trees and destroy of the road safety. All these things are the result of bad environment, and therefore one has to be cautious. One should not play with these environmental factors. And what has been said in the Gita, which I'll narrate before you, all the religion teach respect for nature and the necessary balance of nature and spirit. The higher purpose of life is acquiring the qualities of the nature and the spiritual world. Thank you very much.
Thank you, Justice, for giving us such a marvelous interpretation of ESG and so much of the spirit of the ESG as we know it today lying in the Constitution of India. As an advocate who has been in the field of sustainability now for many years, as a person who has literally been involved with the framing of the current sustainability frameworks in our country, and somebody who has been on both sides, a practitioner, somebody who has studied the law, the regulations, and sitting on several boards of companies where we actually need to write up the BRSR reports. This is a field of vast interest to me in particular, and to our nation, which is at the crossroads today. Today, I will confine myself to the second item that has been entrusted to our panel, legal obligations for businesses under ESG framework, and the challenges and opportunities in implementing ESG-driven compliance programs. Let me draw your attention to the fact that at the heart of the current legal framework lies the SEBI Act of 1992. Because currently BRSR, business responsibility and sustainability reporting, has been made mandatory for the top 1,000 companies by market capitalization and falls under the purview of SEBI. In particular, SEBI circular dated 10th of May 2021 and the SEBI circular dated 22nd July of 2023. These, in fact, prescribe the nature of the reporting, the format, which is the BRSR, and the compulsory nature of compliance to which each of these companies falling under the ambit of the SEBI regulation need to comply with. Because that is so, and because the SEBI Act of 1992 prescribes severe penalties for non-compliance, companies are now beginning to understand that it is not just a matter of tick in the box or fill up a form. The materiality, the requirement of data, hard data, the requirement of putting in place practices that enable the company to fill up BRSR have become literally the manner in which companies have had to internalize the way they perform. Now, SEBI's punishments in 15B and 15H of the SEBI Act prescribe penalties which vary from 1 lakh to 1 lakh per day to a maximum of 1 crore And these penalties are not just in terms of monetary penalties, but the reputational damage that a single notice from SEBI can cause to the top 1,000 companies is phenomenal. And that is why a great deal of compliance now we see between 2021 and 2023-24, the extent of compliance has gone up from year to year. Initially, SEBI said that you write your BRSR report and submit them to us, which works out as pretty much raw, unfiltered data. Today, SEBI has introduced from last year the BRSR core, which means that you not only have to fill up the BRSR form, but get it validated and assured by a certified assurer. And therefore, even before you can submit to SEBI, you must submit to the validated assurer. The entire practice of BRSR today, therefore, is now so transformed that top corporates have no way out to build systems that will ensure compliance. The cost of non-compliance is astronomical. Let me turn my attention now to the latter aspect of what I wanted to say, which is, what are the challenges and what are the opportunities? Let's presume for a minute that a company needs to fill up the BRSR core form. What does it need to do? First thing, it has to build in an internal mechanism, literally an internal department, which must take into consideration the environment, the social, and the governance. And please note that each of three verticals in the ESG have very little relevance to each other. Climate change and the environment is a vast field calling for considerable expertise. Social, CSR, HR, human rights is again a vast field. And corporate law, corporate governance as we know it today, 470 sections of the Companies Act of 2013. Each of these, therefore, is a massive enterprise. And for a corporate to set its mind to actually complying on all the 9 principles of BRSR is a challenging task. You have to draw from the diverse aspects of the company. So the principal challenge is, how do you set a mechanism in your own company to actually ensure that what you are filling up in BRSR subscribes to the highest standards of materiality? Number 2, the cost of putting this together is exponentially growing. Many companies don't have the expertise within their own domain. So they need to hire experts or consultants. And they don't come cheap in this country. Also to understand, particularly at the board level, the nuances of the law, the interpretation of the law, is very hard even for independent directors to grasp. And therefore, it is really quite a challenge. Switching to opportunity. If you incur this cost, if you comply, if you subscribe to the highest standards of materiality and do all of this, what does a company gain? Number 1, brand name. Number 2, stakeholder perception. Number 3, conformity with international practices. And 4th and most importantly, the availability of credit because financiers now more and more are ensuring that you fulfill the ESG standards before you can actually get investment opportunities. And this is not just in India, but across the entire globe. Today, if you are looking for international funding in your company, if you are not ESG compliant, you don't stand a chance. So those briefly were the challenges, the opportunities, and also the larger legal framework that we have done. I'll close with one observation, which is that the legal practice around this is still growing. Case law is still developing. I have a young colleague of mine sitting with me, Pragya, who is now trying to understand where the case law resides. And we are going to track every aspect of the evolving case law. This is a challenging opportunity for this country, and I'm sure that all of you would follow it very closely. Thank you for giving me this opportunity.
Thank you very much. The speaker has interpreted the SEBI, the powers of the SEBI, and all these things are there, but that is a very vast subject. One has to see the principles of the SEBI and the creditor, how it works as a human rights, as a general public. That has to be narrated and that has to be demonstrated a lot. Now I'll request Mr. Sachdeva Hargovindji, who is also a prime mover of this function. He is right hand of Mr. Singhi, who is the who has arranged the entire conference here, and Mr. Sachdeva will also demonstrate about the legal field and about the constitutional aspect of the matter.
Thank you, Judge Mr. Tandon. Mahatma Gandhi envisioned an India where people will live in villages. Unfortunately, the reverse happened. The migration took place towards cities, and today every citizen is struggling to breathe fresh air, lead a hygienic life, or move around freely in roads which are congested with traffic. Now, this Mother Earth is given to each one of us in trust to be utilized, to be lived nicely, and then to be passed on to our next generation, our children, so that they can also prosper and take the humanity forward. Unfortunately, the way we indulged in deforestation, massive urbanization, industrialization, we have also negated that dream, that vision. And today we are at a standstill position wherein people are suffering from severe diseases and calamities like corona. They frequent us because of non-observance of the standards of cleanliness in life. ESG is a direction, a small step in rectifying that error. I would focus from the angle of a former banker, and as Judge has ordered me, I will also try to bring in law, whatever limited legal knowledge I have pertaining to ESG. Friends, when we are lending, we are only seeing the profit a bank can make, but we do not see the profit earth can gain out of that lending. Today, State Bank of India, unfortunately my bank, is the largest lender to coal financing in world. Just imagine. And the loans of corporates like Indian Oil Corporation, Burma Shell, and leading oil companies are sanctioned within 48 hours, and the quantums are 1,500 crore to 2,000 crore per loan. Whereas a small loan, for an entrepreneur or MSME unit takes more than 1 week. So the anxiety to book profit by funding big names like Indian Oil Corporation is actually, making this ESG exercise a very challenging exercise. As such, bankers should ensure that in the rating rationale they conduct while assessing a loan proposal, they must give negative marks to a company which is polluting the ambience, the environment, because once that company is non-compliant to ESG, that is, basically environment, then the other aspects, that is the social aspect and the corporate governance aspects, and thank you, Judge, you have added that G in ESG should stand for global aspects also. So those aspects are also overlooked. I'll just briefly tell how. Once, we are polluting the atmosphere, then we are only for profit. We want our product to somehow manufacture in large numbers and then sell it and make profit. Now, in doing so, the corporate governance is thrown to dustbin because we do not observe the laws. We create pollution, we make people work extra time without compensating them properly. We do gender discrimination because long hours of working women are sent home, but males, they are brought into third shift, and our old machinery works for 24 hours a day, polluting the ambience day in, day out. Similarly, in social aspect of this, we find that there are a lot of lacuna. People are indulging. They are not paying proper wages. They are not creating even proper toilets for their labor. So a person who is non-compliant to ESG is actually a destroyer of this generation. As such, I'm sure that this House will really welcome the implementation of ESG. Now the legal aspect. Legal aspect is that sir is heading a lot of courts and a lot of senior judges or lawyers are sitting here. Now NCLT was introduced saying that it will bring revival and resolution of the debts, sustain some employments, sustain some old machinery to still provide some productivity to aid to the nation's economy and GDP. But unfortunately, judges are not giving any order that a unit which is being revived should also be ESG compliant. We are only seeing financial ratios. We are telling give this much to labor, this much to creditors, this much to suppliers, this much to secured creditor. But sir, we are not getting judgments wherein you must order that each unit which I am reviving and giving a fresh lease of life should be ESG compliant, because only then India will start improving somewhere. Now more than 56,000 companies are confronting NCLT decisions. I request that if that could be brought in, then probably we will be able to do justice. Friends, now RBI has started a very good concept of green bonds. They are paying extra interest if you invest in the green bond FDRs or instruments, and those funds are essentially given to companies who are doing green manufacturing, observing ESG norms. So legally things have started happening, and I'm sure with the voice which will go from this esteemed House, ESG will be harnessed by each and every individual in his personal life and all the corporates in their business lives to make this world a better place to live. Thank you very much.
Thank you, Mr. Sachdeva-ji. You have rightly emphasized the role of NCLT. NCLT is directly connected with environmental issue, in as much as I have seen that when the roads are being constructed and those roads are being such that the trees are fallen down, then the NCLT interferes and those fallen of the trees are being restricted. And therefore NCLT is deeply connected with the environmental issue, and he has rightly pointed out that all these corporate sectors should also follow up our environmental issue and all these issues, GST and all that, and we should be very sincere to all this. One should be sincere to this environmental issue and also to the corporate law. Thank you very much. Now I'll request Mr. Gupta ji to also demonstrate about the legal field.
Thank you so much. Good afternoon. All of you would tend to agree with me that the world is changing, and it is changing very, very significantly and rapidly. I am not only talking about the last 2.5 years when the world as a whole was impacted by COVID-19 pandemic, but even otherwise, if you look back 2 or 3 decades, there have been some significant changes which have taken place in this world, which have changed the way we live our life and also changed the way the businesses function in the marketplace. It's a view world which is highly vulnerable, very, very volatile, very uncertain, hugely complex, very ambiguous, and to top it all, there is always that fear of uncertainty lurking at the back of our mind. You don't really know what might happen next 6 months, 1 year, 2 years down the line. In this very, very dynamic, challenging, and volatile world environment, the businesses are facing a lot of challenges. If you check out corporate performance, both for so-called old gold-plated companies still existing, still sustaining in the marketplace, and also large number of startups which are mushrooming all over, including India, many companies have profitless turnover. They have a great top line, but end of the day, there's no profit. Many companies have cashless profit. You have profit as per profit and loss account, but there's no cash, there's no liquidity. But when you look at their valuations, wow, skyrocketing, soaring very, very high. The point that I'm trying to focus on here is the measures of corporate performance have now undergone a change. I'm not saying profit is not important. You got to be profitable with a view to be able to sustain in the market, but the path to profit now passes through ESG. You got to make profit, yes, for sure, but at the same time being environmentally, socially, as well as through effective governance, architecture, and mechanism. That's where the companies are focusing on, because the stakeholders today are looking for ability of the company to create value, not value in the sense of valuation, real value. Ability of the company to be able to preserve value, and ability of the company to be able to enhance that value going forward on a sustainable basis. That is what the stakeholders are demanding from the companies. So only those companies which focus on profit with purpose. You make profit, you have to make profit, otherwise you will not survive. But profit with purpose, triple bottom line concept, where you look at not only profit, but also people and the environment side by side, so as to ensure equitable development. We all celebrated Azadi Ka Amrit Mahotsav. Naturally, we all took a view as to where are we today as a nation. And we are very proud to say we are the 5th largest economy of the world. Out of 195 countries, 5th largest economy, it's a great achievement. And mind you, 75 years in the life of a nation is not a long period. And will become 3rd largest economy of the world within the next few years for sure. And we are looking at Amrit Kal, India becoming a developed nation by 2047, culminating with 100 years of India's political independence. But then we are focusing on inclusive growth, Sabka Saath, Sabka Vikas. As of now, we have done great things. We built great infrastructure. Our GDP number is pretty good, but the development hasn't reached the bottom of the pyramid. There are many people yet who are underprivileged, who are less privileged, who are underserved, who don't have access to the various facilities which are available to people living in the cities, and that's what has got to be ensured by and through the purposeful and meaningful implementation of the ESG principles by all concerned. So far as the legal dimension of ESG is concerned, legally speaking, if you integrate corporate laws, labor laws, social laws, environmental laws, the intersection that you reach is what is called ESG-driven legal practice or law practice. What is required to summarize in one way or one sentence is, you got to probably change your mindset that when you sit as a judge or when you look at a particular legal matter or a legal case, look at it not only from the point of view of the litigation or the matter involved. Ultimately, everything boils down to how does it impact, how is it going to impact the quality of the human life? And that's what ESG is all about. Thank you so much.
Thank you, Mr. Gupta ji. He has all demonstrated about the legal field, but one thing has left, that our Globalization Information Technology Act has been drafted and is codified. There is no law for artificial intelligence. What is going on, it has not been yet codified, and that is the drawback, either because the topic of today is environment, social and globalization. For social globalization, we must have a codified law. The digital arrests which are being going on daily newspaper is filled up. The government is not taking steps to codify the law. There was one section, section 66A, that is in the Information Technology Act, that itself has been deleted. Now you can pass on any information to anybody after the deletion of, that is the judgment of Shia Singhal's case, and therefore there is no restriction, nothing of the kind, and therefore I'll pray to the government and also pray to this organization to demonstrate that there must be a law, codified law on the artificial intelligence, and there must be some punishment, that is the punitive punishment should be there, and that is why I say that the environmental, social and globalization only will be attracted and only will be established only when some codified law will be introduced. Thank you for today's seminar. Thank you.
Thank you very much, sir, for sharing your thoughts with all of us and for conducting this session. A big thank you to all the panelists as well for sharing their views with all of us. Ladies and gentlemen, before we finally conclude, may I please invite Lieutenant General C.P. Mohanty ji to kindly please present mementos, tokens of respect for each of our speakers today. Welcoming Lieutenant General C.P. Mohanty on the dais. A big round of applause. Ladies and gentlemen, please put your hands together. We thank our panelists, beginning with Dr. Bhaskar Chatterjee. Thank you very much, sir, for your sharings. A big round of applause to each of our presenters. Mr. Hargovind Sachdev. Thank you very much for sharing your thoughts. Dr. S.K. Gupta. Dr. S.K. Gupta. A big round of applause. Followed by the moderator, Justice Rajesh Tandonji. A big round of applause for the moderator, Justice Tandon. Thank you very much for conducting this session. Thank you for joining us in this panel. Thank you very much. We'll have a group picture Before we dive into the fourth and the final session for the day on AI and justice, navigating legal security and ethical frontiers in a progressive world. A topic which seems really contemporary. Thank you very much. So big thank you to all the panelists, moderator, and thank you Lieutenant General C.P. Mohanty ji for presenting the mementos. And with this, ladies and gentlemen, we'll now dive straight into the final session for the day, the final panel discussion, which is on AI and justice, navigating legal, security, and ethical frontiers in a progressive world. We'll begin by inviting the panelists. Dr. Pavan Duggal, Advocate, Supreme Court of India. May I request you, sir, to please join us on the dais. Mr. Pavan Duggal, founder and chairman of the International Commission on Cyber Security Law, is a globally renowned expert in cyber law, cyber security law, and e-commerce law. We welcome Dr. Pavan Duggal on the dais. Moving forward and inviting the other panelists, Lieutenant General C.P. Mohanty, former Vice Chief of Army Staff, presently Member Administration, Armed Forces Tribunal. We welcome you, sir, on the dais. Lieutenant General C.P. Mohanty, PVSM, AVSM, SM, VSM, retired, is a highly decorated and experienced general officer with over 38 years of service in the Indian Army. He is an alumnus of prestigious institutions like RIMC, NDA, and IMA. We welcome you on the dais. We welcome Mr. Pradeep Rai, Senior Advocate, Supreme Court of India, to please join us. A distinguished senior advocate practicing at Supreme Court of India, currently holding the esteemed position of Chairman of the India Legal Research Foundation and India Legal Aid Center. Mr. Rai's impressive career also includes 2 terms as the Vice President of Supreme Court Bar Association. We welcome you on the dais. And with this, we invite the moderator to please join us on the dais, Dr. G. Satish Reddy, former Chairman DRDO, Government of India, to please join us. Ladies and gentlemen, a big round of applause for Dr. G. Satish Reddy, who is a distinguished aerospace scientist and the former chairman of the Defense Research and Development Organization, with over 3 decades of experience in defense technology and research. We invite Mr. Kazim Rizvi, founding director, The Dialogue, to please join us. A public policy think tank based out of New Delhi, an important voice in India's tech policy ecosystem, Mr. Kazim works on the intersection of technology, policy and society with a focus on evidence-based research and discourse. We welcome you, Mr. Kazim Rizvi. With this, may I please request the moderator, Dr. G. Satish Reddy, to kindly please begin the proceedings of the session from here, sir.
Good afternoon, everyone. We are seeing here anyway. Good afternoon, everyone. I think this is the last session. Probably, actually, we can see also post-lunch, it has become very thin. And I don't know, hope the people who are there also active enough to participate in the discussion what we have. And anyway, the discussion is on AI. So AI takes care of, we don't have to do much. So that's how probably. Anyway, in the last couple of years, as morning the Attorney General also has mentioned, technology started playing a major role with AI entering into the every sphere of the activities in the society. And one of the important things as the subject concerned today is justice. Navigating the justice through AI is one of the important aspects. It has multiple things connected to it. One is with AI, things become very simpler, and it many times it doesn't have to depend on single person's capabilities to analyze many things. And with AI having a large database, large number of cases, going through the whole data, going through the cases, analyzing, and can provide a proper perspective, which at times many human beings may not be able to go through that, or may not be able to analyze, or somebody doesn't have that much of an analytical capability and things like that. So it helps in a way, in a big way. At the same time, there are connected issues. Depends on the algorithms, depends on the data sets, and what not available to the platform. Based on that, the analytics, the opinions, or the reasonings are provided, which could become biased. And so then, who should be fixed the responsibility is a question mark. Whether the developer, or the user, or the system, what it is and how. There is one more issue connected to it. Then there are security aspects connected to it. Whether the data security, both ways, whether available data, somebody can, because you made it so much open and so data stealing, or data corruption, or infiltrating the data with malicious data to make the analysis or judgment of the AI systems is biased or incorrect. So this is another issue. Particularly with the cyber security coming into picture in a big way, this becomes one of the major issues. And along with this, the ethical issues also come with respect to the AI. The ethical, moral related aspects what we need to build in. And particularly, as I said, whether the algorithms which have gone into the system have all this. There are many ideas which float, which makes life for many people, common people, maybe simpler. And what you need to really look for a legal source, probably a AI legal source, a AI lawyer, AI advocate will be able to provide all that very simple to a common man also. So there are multiple issues connected, and what type of regulations and what type of policies we need to build this to see that the complete AI is only helping in to get a efficient, quicker and right judgment and right process or right decisions, where right from it's a bail to parole to or a decision judgment, whatever it is, how it can be useful. So this is how I feel, primarily as a technologist, what I look at it with the perspective of looking at the justice. We have very eminent personalities here who have their own specializations in each and every field. And particularly we have a Lieutenant General here who was the Vice Chief of Army Staff, and looking at that aspect, technological aspects, and into the other domains of it, and particularly defense and military domain also, we get a perspective. So with that, I'd like to go to get perspective from all these eminent personalities who are there here. I'll start with Mr. Rijvi, as particularly looking into the policies and related aspects which you are the specialization. I'd like to give your perspective on this theme of AI and justice and concerned issues and policies what need to be taken up. Thank you.
Thank you. I hope I'm audible. Thank you, Dr. Reddy, for your opening speech. Really insightful. And I think you captured all the key issues which AI is trying to grapple today and what we are looking at in India. I think the focus of the conversation is quite broad, and it's great to see that we are talking about AI in defense, legal systems, cybersecurity, AI governance, IP law, and accountability. But I would like to focus on three main issues, sir. Number one is the fact that AI is here to stay, and it's ubiquitous. It's being used across multiple platforms for various purposes in healthcare, finance, legal, etc. First and foremost, sir, we need to identify and implement responsible AI principles. I think that's the most important aspect when we are looking at coming up with a future governance regulation. The first step towards making sure that we move towards safer AI is to implement responsible AI practices. And these include practices such as bias mitigation. We have to make sure that the technology is fair, it's non-discriminatory. The data sets which are being, the AI model is being trained on are basically as diverse and as accurate as possible. Data protection and privacy is fundamental. In fact, yesterday, the Ministry of IT has released the draft data protection rules. So we have to make sure that the model respects and adheres to the privacy standards in India. Cybersecurity is critical, and you have to demonstrate that as a model developer, you are implementing all types of latest guidelines and technical strategies to protect the data of Indian citizens. And these are some of these factors which play a big role when it comes to making AI safe. Having said that, there are certain intersectional conversations and discussions which are going on right now with regard to AI and copyright. And we are also looking at conversations with respect to AI and liability. There is a lot happening when it comes to safety institutes and AI. Let me touch upon copyright and AI a little bit because this is also part of the conversation here. And many of you may be aware that ANI, which is one of the larger publication houses, has sued OpenAI in the Delhi High Court where the matter is going on. There are two contentious issues. Number one, what is the protection guaranteed to publishers, original authors of content, which is then trained by the AI models? And number two is, who owns the copyright when the model is producing an output? These are two issues which are being debated right now. On the first, the Indian Copyright Act, if you look at the Indian copyright law, allows for fair dealing. And there are arguments globally. By the way, there are 35 cases across the world, in the US, in Europe, where publishers have sued AI model developers that their data sets are being used to train the models without their permission. However, at the same time, I think we have to be very cognizant of the fact that in India, we have a very robust, growing AI startup ecosystem. While it's important to make sure that the original author gets the protection required and gets the fair remuneration for his or her work, we also need to be mindful that there are Indian startups which are beginning to process and collect and train data sets to develop their own models. If we restrict the ability of Indian startups and entrepreneurs to train models, then the large companies and companies which have already done it for years will have a first mover advantage, and they will never be, I mean, competition will become difficult, startups will not be able to compete with them. So whatever amendments or discussions we are having in the copyright regime, this is an important factor to have. The second factor is, who owns the copyright of the output which is produced? Is it owned by the application? Is it owned by the prompt giver? Who owns it? And it's a moot point. There is no clear jurisdictional guidance provided right now in the world with respect to who owns the copyright. But in general terms, the AI model developers themselves put it out in their policies that the output is owned by the prompt giver, because the prompt giver takes a call in terms of the questions they want to ask and what are the direction they want to take the AI model to. But at the same time, there is jurisdictional gap over here, and there are debates on either side, and it's not it's not an issue which is over. It's just picked up, and there are debates going on this. The third issue which I want to sort of focus on is AI in judicial and legal systems. And I think there are multiple startups which are already developing legal tech solutions, AI legal tech solutions. But there are issues with respect to accuracy of the large language models and the fact that they hallucinate. How reliable are these models for lawyers to be used or for judges to be used when it comes to providing judgments, or for lawyers to use them when it comes to developing briefs or their petitions, etc. So keeping that in mind, I think it's important for us to make sure that we build in certain robust technical standards. And these technical standards will only help us in outlining how you make your AI more accurate and your AI more safer. At the global level, we are having conversations where multiple countries have now come together and formed AI safety institutes. There is a global network of AI safety institutes which is looking at technical alignment and standards, and I think for India it's important to be part of these conversations and to inform what should be the technical alignment. Why this is necessary is because what we don't want is globally the world develops certain guidelines and standards and India loses out or India misses out from it because India is not participating at the table or doesn't have an AI institutes of its own. We cannot miss the bus. It's imperative that we inform the technical standards and the guidelines so that it benefits our local startup ecosystem. And if you're talking about AI regulation, for whom do we regulate? Do we regulate to prevent harms, or do we regulate to support growth of the Indian industry? Both can be achieved at the same time. Right now, what is necessary is at an industry level, companies setting up robust best practices and standards to make AI safer, voluntary commitments, and then ensuring that the Indian startups get access to data, they get access to good compute, they get access to talent, and for this, whatever necessary regulation or whatever necessary policies are needed, government might consider those. Thank you.
Very good, Mr. Richvi. You, I think, touched upon the right aspects of the AI, the various startups, industries, what they're doing, how do you actually bring in mechanisms to make AI can be utilized very positively and it will not have its own repercussions on the society. Thank you. Now actually I request Mr. Pradeep Roy, Senior Advocate, Supreme Court. It is also very interesting to know that the Chairman of the Indian Legal Research Foundation and India Legal Aid Center, and as a long career, includes 2 terms as the Vice President of the Supreme Court Bar Association. So with being the Chairman of the Research Initiatives Foundation, he can actually throw a lot of light into the AI and AI related impacts on the judicial system. Thank you, Mr. Roy.
Thank you for this opportunity. This is such a topic which is now being discussed and being implemented across the globe. Our Supreme Court also witnessed recently when they started working on a special softwares and AI generated programs, especially for the judges to write judgment, but not only final judgment is not that, but most of the part to assemble everything, make it concise, make the arguments in place they are utilizing it. We started doing it during Justice Chanchur's time, and it was developed in UK. Most of the countries, they are using it, especially US and UK, but I personally feel that whenever we are working on these programs, especially for the delivery of the judgments, then we have to consider several other aspects of society. If it is not prepared and generated, considering the social aspects and the society of the particular nation, then the other softwares may not be fit for the society. Like, suppose in India, you are delivering a judgment, especially in the keeping in view the case of Meghalaya. The fact is that a person, a lady, gives you a pumpkin, and you accept that pumpkin thinking that this is the fresh vegetable, and you go home. But in fact, it is a proposal of marriage and you have accepted it. So that judgment cannot be delivered unless you program it considering the social aspect and sixth schedule and customary laws. Similarly, a very famous case in the US, where in the baseball tournament, whenever a player hits any ball in the stadium, and any person who is witnessing or the viewer of the match, if he catches the ball, he is allowed to get $10,000. At one incident, when the ball went to the stadium, a person picked the ball, but many other co-viewers, they hold him and they snatched the ball, and finally it was in the possession of someone who kept in the pocket, and finally he claimed that this ball belongs to me and I am entitled to get this $10,000. This judgment was really very difficult. AI said that because the rule is that whoever have the ball, they will get $10,000. So generally it was supposed to go to the person who has finally got the ball. And when this matter came to decide by adding the human angle, it was decided that both the persons who first picked the ball and later the last person who was in possession, they will share this money 50-50. Similarly, like Ram Mandir temple case in India, suppose this judgment was being delivered by AI, what would have been the future of that case? I don't say, because in this case there was no other view possible other than what the judgment was delivered. So that is the question which we think here, because we are understand the society, social fabric and the conditions in India. But suppose it is the AI generated program which is delivering the judgment completely based on the facts of the case, then the judgment would have been a bit different. And the final judgment what came out, that I think that that was the only way possible considering the Indian circumstances. So not only this, even like this green benches, we decide that several times that they want felling of trees and the permissions to construct 4-lane, 5-lane in Uttarakhand especially, when the Supreme Court stayed it on the grounds of law. Finally, after the Prime Minister's intervention, he said the development is also necessary and we have to survive with having both the perspectives, the development and protection of environment. And that's how this program was cleared, this judgment was delivered by the Supreme Court, in which they allowed construction of roads by even going with the minimum loss to the environment. At the same time, there are responsibilities, like what rightly Mr. Kazim Rizvi pointed out, that whenever you are entering into any program which is AI based, like suppose digital surgeries, nowadays this robotic surgery, it is a concept. So if a doctor is conducting a surgery and something occurs, who is responsible? Obviously doctor. But the moment he claims the malfunctioning of the robotic machine or that equipment, at that point of time the responsibility fixing is really difficult. Nowadays the time has come when we are going to have driverless cars, we are going to have pilotless aeroplanes. So in those circumstances, we all have to be very careful considering the growth of technology, considering the future litigation at the same time. And whenever we are going to have the programs completely as per the society, Indian society, keeping the regionalism, keeping the customary law, the provisions of our constitution, because we accept diversity. In our diverse laws, like there are several districts in Northeast where you will not find courts. The district councils, who are the tribal leaders, they may not have the education of law. They are the district courts, and they pass the orders. And their laws, their judgment passed in customary law is accepted. So whenever you start analyzing those customary laws, I think that unless you incorporate everything and you make it intelligent enough to deal with the facts and circumstances, it will be difficult. But this is the future, sir. And AI can't be ignored. Now this judiciary, lawyers, we all are using it at some extent. This younger generation is, they are better equipped, they have better knowledge. For us, it is a bit difficult. Whenever we start working on something, we have to take help from them, they guide us. But whenever, like a judges, whenever they are writing judgments, earlier it was really difficult, sir, for us to take out the books, finding out the judgments. Nowadays, we get it very easily. That is the minimum AI could do. But now, even judgment writing, analyzing the facts, previous judgments passed by the Supreme Court, and then the foundation of it. So all these things are happening. There was a law, sir, earlier, pre-independence, and even in British law, that if a tanga, like a ikka, if you are going with horse cart, if you are going and it comes with some accident and all, the horse was also accused. And there have been around 48 trials in Calcutta in relation to horses only. Horse was the accused, because horse made the mistake, not the person who was handling the horse. Later, after post-independence, laws changed, and gradually we are seeing the laws in currently which is in place. So, though I am a last minute arrangement by Sumitra ji, I have not prepared, but whatever I know and whatever I have witnessed, based on that, I personally feel that AIs are the necessity of the legal world. It has made our jobs easier. At the same time, we have to consider the social norms, society, Indian laws, and then globally accepted other forums which accept our principles. If you incorporate everything, we will be on the right direction. And I hope that this seminar and this program, this entire conversation is going to help our country, our audiences, at the same time to our courts and proceeding young lawyers and everyone. Thank you so much, sir.
Thank you. At times, actually, with the vast knowledge what you have, and suddenly taking up a task like this and giving an opinion, sometimes it is better than giving a prepared one. So it actually comes as a naive answer, and it will be a good answer also. You gave a very good perspective of AI, the utilities of it, and also the problems associated with that, what could be the things and all that. So very good. And let us see how future tells us and how we are going to take it forward, and what type of AI tools come in, and what is the refined tools of AI which are going to come. Now, I request Lieutenant General Mohanty, CP Mohanty, is PVSM, AVSM, SM, VSM, and he was the Vice Chief of Army Staff, and then as General and turned into legal system, is a member of the Armed Forces Tribunal. That's how he has also entered into the legal system and judiciary related aspects. Request General Mohanty to give his perspective now.
Not working. Hello. Yeah. Thank you, Dr. Reddy. First of all, I must confess that whatever I'm speaking is not AI generated. And secondly, whatever I'm speaking is primarily for the young audience, because I thought I'll just share my views, because Army, Navy, and Air Force, all three have been forefront in generation of AI-related technology. So that's where, rather than going into the little higher level things, let me just give you certain perspectives, what can be useful for our legal system. Now, it is like if I have to really go to Google and type two words, that is artificial intelligence
and law, I'll get plethora of my own speech. And it's like a maverick juvenile telling probably a wise old man what I should speak about him. But then it is something that is here to stay. What we need to do is to tame him. It is inevitable. We have to tame him and also learn from him. Given the legal landscape in the world today, I believe that AI is not a tool, but it's a transformative force which will enhance the access of the entire nation to justice. The private sector has already taken a lead, followed by the PSUs, all the public sector, and armed forces. In the second half of the century, we have found that this is something which has completely transformed the battlefield. This is the next most important thing that has happened after the introduction of Air Force into the battle. So if that be so, there are challenges. Today we already have in the Supreme Court, Supas is there, Suvas is there, and Haryana High Court, they're already using ChatGPT to decide the bail pleas. That is in 2023. But what are the challenges? Now, challenges are far too many. Yet, when we are looking at the challenges, after all, we've had challenges as far as since the advent of ever since the motor vehicles were invented. That was 140 years back. We've had thousands or lakhs of accidents. But now today we have driverless cars, which are completely AI driven. Similarly in Air Force, the aircrafts, which were invented 120 years back. Have you stopped flying? There are a total of, as per my records that is available to me, 1918 accidents have happened. The aviation accidents. Even then we are still going strong. And today also the RPVs, remotely piloted vehicles, these are also AI related. So how are we flying them? There are accidents, but we are still going ahead with that. Now let me take you into two scenarios. The scenario of the Indian legal system or the judicial system that is existing, that is the Act 1 of the play, and the Act 2 is what is going to happen in 2047. 2047 is the 100th year of Indian independence. Now what is going to be the situation then? It is just a perspective that I'm going to present before you. Today we have got backlog of 40 million cases in India. Legal representation is restricted and high legal fees. And there is a substantial amount of time that is taken to adjudicate the cases. Let's go to 47. With the advent of AI, having perfected the AI, I will talk about the phases a bit. The applicant doesn't have to go to a lawyer. Unfortunately, probably the legal fraternity will have lesser relevance in 2047. Because the applicant has to go to the AI, file his case, and accordingly the application will be generated which can be filed automatically in the court. The complete business of the court will be AI related. The reliance of the case laws, arguments in the courts will not be necessary any longer. The transcripts of the arguments, if at all, only the differences to the arguments will already be available. And the most challenging work, like in last 2 years that I have been in the AFT, I realized one of the things that which plays on our mind is to, when the order is reserved, how to finalize the order and then deliver the verdict. That itself is substantial time taking. You have to go through the files, you got to dictate the order, and then go through the draft, then correct the draft, then get it checked by the others, and finally give the verdict. So sometimes it takes 6 months. 6 months is the time given by the Supreme Court, as you all know, but it sometimes takes even more than that. So therefore, this is going to be once again a matter of hours, not even days. Yet, the human being will continue to remain relevant. It is the ethic. what we are going to add as a human being, what is the relevance of the judge then? If everything is going to be done by the AI, what will the judge do? He will add ethics. He will confirm what is being delivered to him by the AI, the accuracy and the legality. That is where the human interface comes in. Now, if I talk about bit of the ethics, take you on to Ramayana. If there was AI available then, Ram wouldn't have killed Bali. The AI arrow which was delivered would have killed both Bali and Sugriv. So therefore, this is where the human being counts. This is that last mile connectivity where the judges, where the lawyers will be of relevance. Now what will happen at the end, the backlog would probably go down to 4 lakhs, just about 4 lakhs or even lesser than that. There may not be backlogs at all. And we'll be able to reach every nook and corner of the country. Justice will be available on each one's mobile. And that time probably mobile will not be there as an instrument in your hand. It will be part of your body. It's already been. I'm not talking about any science fiction. It's a fact that is going to be. However, what we have to ensure that the AI remains a loyal servant. It does not become a dominating master. At the same time, while I made a threat to the lawyers that you might lose your job, you will never lose your job. Only thing, your works will become simple. There have been much bigger developments in many of the countries. I'm not getting into the details, but simply to take certain names, USA has got Compass, wherein it is led to predictive policing and allocation of the police resources. China, yet another leader in this field, they have smart courts. They're promoting efficiency in the judicial resource management. They're allowing the judges to go in for more intricate cases, leaving the lesser important cases to the AI. In UK, they have something called as a HART, Harm Assessment Risk Tool. Now, this is also a very interesting case. But what is most important is Brazil. Now, in Brazil, a case which is supposed to be done in, say, total cumulative time of 40 hours, it is just being done in 5 minutes. That is the amount of time that is taken, even today. So India is not far behind. Technologically, we are a giant in the world. So in the legal field, we have a tremendous amount of potential. And this potential, why am I saying that he is going to take 2047? Because we have got to tame this animal. Otherwise, this cannot be allowed to become a master. And how do we achieve this aim, the dream by 2047? It has got to have certain components. Firstly, the case management system to manage our cases and track the schedule of hearings. The second one is predictive analysis. I've had an interaction with Mr. Singhi. He said that it is already in place. AI-powered legal research tools to help our the legal researchers, and also research by the legal as well as the judicial fraternity. Automatic documentation, which takes a tremendous amount of time, that is going to be reduced phenomenally. Artificial intelligence chatbots and visual assistants. The learning platforms, it's a very important thing because it requires skilling by us and multilingual support system, because every case today is being handled by various states where the judgments, where the arguments are in their local language. So this translation will have to be done. Otherwise, you will have leave granted becoming chutti swikar. So we cannot have this kind of a thing happening by the AI itself. And even we have to also ensure that the threats of misuse of AI, that has got to be negated, and the innovations have to go hand in hand with all other developments that is taking place across the world. The recent the virtual arrests cannot be also repeated in AI, like having fake judgments, fake arrests, and reliance on the case laws which are non-existent. So therefore, we have to ensure that this unruly stallion becomes a obedient horse. I would like to propose for the decision makers a way forward, quickly a way forward in 3 phases. First and foremost, this is my experience in the armed forces. I'm taking, pardon me for taking a little longer, but this is the last bit I wanted to speak about. It has got to be in a manner as a phased project implementation. It could be top down, that is from the Supreme Court to High Court to the District Court, or bottoms up, that is from the High Court to the District Court to High Court to then Supreme Court. I would propose bottoms up, having a pilot project, because it is finally the Supreme Court which should have the last word. The moment Supreme Court becomes a test bed, it will not possible to withstand this. So therefore it must start with a district court of a particular state, thereafter the state high court, and then finally coming on to the Supreme Court. Then the project agency has to be created at the highest level. Creation of a joint working group again at the highest level to monitor all these activities. Implementation by signing MOUs with PSUs or maybe many of these AI firms which are there existing in the country. It may be the best in the world. And the policy, roadmap, data handling and the infrastructure creation has to be done. And similarly the cyber security. The countering of the social media and international threats is something that we need to negate. And this entire thing has to be tested by mute courts, by simulation exercises, by AI application which has got to be validated. And of course, to add to that will be logistics and financing. And this has got to continue with the continuous upgradations, because what is today the technology is going to be far ahead in 2047. So if each phase is going to take 5 years, so 5 into 3, 15 years, 2015, so it is coming to about say 2040. So by 2047, the legal system of India has to get integrated with the rest of the world. There are comparative studies which have got to be done by case studies in the global scenarios. More is the data, more is the accuracy. We are seeing it. As the data builds up, your percentage of accuracy keeps on increasing. And I said about the ethics. Ethics is something which cannot be ever lost sight of. And ultimately, it should be such that the AI-based, it has got to be a world, one law. If I may just shorten it to say OWOL. And at the end, I would like to quote Stephen Hawking, who has said in 2018, it'll either be the best thing that has ever happened to us, or it will be the worst thing. If you are not careful, it very well may be the last thing that will happen. Thank you very much.
Thank you, General Monty. You have given a lot of new perspectives, starting from AI in armed forces and armed forces, how they are taking forward AI and how AI system has entered into the legal system or judiciary system now, and then how AI is not ultimate, always a human being is essential, whether for the last mileage points or other way around also, whichever way it is. Many things you have covered, and thank you. Now we have the Dr. Pavan Duggal. Particularly, I am also interested in what he would be saying, primarily because he is the founder and chairman of the International Commission on Cyber Security Law, which is very important, and also he is a renowned expert in that. And as cyber security has become a major day-to-day problem in our lives now, leaving aside the issues connected to data, data storage or data security or various other issues, actually the way the cyber security thefts, choris, what are happening now today, on an average today in our country, it is about 22 lakh rupees we are losing per minute. this is the general order of the day today, how people are utilizing the tools. Probably some of them are using even AI tools. AI and cybersecurity together jointly is an integrated system which has become AI and cybersecurity, and that is creating a big menace. And how do we deal with it? How we can bring in regulation systems and whatnot, everything and all that is one of the important aspects what we need to look at. So Dr. Pavan Dugal, with his research in this and experience in this and bringing in the law particularly, I'd like to hear a lot from you. Thank you.
Thank you, Mr. Chairperson. 75 hours back, something happened. And that has a direct bearing on what we talk. The Illinois Supreme Court has now implemented its AI policy. The first Supreme Court in the world which has said in categorical terms what is the American judiciary wanting of AI. If you read it, you're surprised, maybe even shocked. Why? Because they say the use of AI is expected and is encouraged and has not to be discouraged. Number two, they're saying, sorry, there's now no need for disclosing by anyone, whether it's a litigant, whether it's a lawyer, whether it's a judge, that the output that they are creating has been created with or without AI. This is so dramatically different from what the American courts were doing a few months back. This is what is completely a U-turn from what we saw, where two American lawyers were fined $5,000 because they had gone to ChatGPT for creating these written arguments, and the ChatGPT had actually given in 6 American cases, all of which were fake. The parties didn't exist, the litigations never happened, the judgments never came. But lo and behold, because the AI gave such judgments, and the lawyers asked AI, you're giving me judgments, I hope they are correct. The AI said, absolutely correct, please go ahead. So they relied upon it only to realize that they are being fined. They were lucky. Their license didn't get suspended. From those days till the Illinois Supreme Court AI policy, it's a different ballgame altogether. And I think as we are talking, I'm just closing my eyes and thinking, look, if we were to do the same session in 365 days, a lot of what we are going to talk will be irrelevant. Why? Because AI is moving at a phenomenal pace. And we are still thinking of AI as the internet. So the 2024 of the world is the 1996 of the internet. The internet was at its nascent stage, AI is at a nascent stage. Sorry. AI is moving far, far more rapidly. And now we have a bigger problem. You want to use AI for justice? On the one hand, have the carefree approach of the American thought process. On the other hand, have the very hesitant, cautious approach of judiciaries across the world. Where do you pass the distinction? Which side of the road the camel is going to sit? No one can say. But yes, certain things can be said, definitely. Yesterday night, the Ministry of Electronics and Information Technology uploaded on the internet the draft rules under the Digital Personal Data Protection Act 2023. These rules instantaneously got to be analyzed by AI. Everybody went to AI and got the AI inputs. So at midnight, I happened to go to one of these AI platforms, and I happened to ask questions about the DPDP Act, having worked extensively in this space. And I was merrily asking questions, and the program was merrily giving me answers. Till such time, I said my patience is running out, and I called out AI to say, whatever answers you've given me are completely false, because they don't reflect the correct nuances. The correct nuances are this, this, this. To which the AI said, sorry, I was mistaken. I now correct myself and give you the corrected answers. This happened because I knew the nuances. What happens when a person doesn't know the nuances? When you believe that AI is the next magical wand, In India, in Munna Bhai versus MBBS, we have the Jadoo Ki Chappi. We are expecting the AI to have us Jadoo Ki Chappi. It doesn't work. It's not going to work like that. And on bigger issues, we have another bigger problem. Indians are undergoing two remarkable revolutions. And when you marry that sociological with the AI phenomenon, I begin to see disastrous results. Number one, India is going through the great Indian vomiting revolution, where Indians are vomiting data about their personal, professional, social lives, on the internet, on AI, without thinking of the ramifications. And the second is the great Indian recording revolution, where Indians are recording information about themselves. And after recording, forgetting about it, where your recording is going on. And now the new trend is upload your recordings on AI to analyze, have it analyzed by AI, without thinking of either your privacy or your cyber security or your digital rights. In the earlier years, we used to say that Google knows more than your wife and family. Those days are dead and gone. Today, an OpenAI knows far more about you, your mind, than even Google. Why? I give a query to Google, I get 20 search results, and I have to go and search. I give one query to AI, AI gives me exact answers to what I'm asking for. So the latest program of OpenAI has got a new function. It's called the memory function. They constantly keep on updating that memory function. Anything, whatever you ask, gets uploaded into the memory. So if I have to hack you, if I have to target you, all I have to do is to hack that memory function. And lo and behold, I have the most intimate knowledge of who you are, what you are, where you're going in. So we are talking about AI and justice phenomenally, wonderfully well. Yes, certain low-hanging fruits, no problems. Maybe the challan cases could be jumbled together. Maybe AI can get them off quickly. But the moment you start going to contentious matters, you have a bigger problem. Why? Because most of this AI has been fed on data that's non-Indian. That's been fed on American data. So its perspectives of looking at things is American, is more colonialistic rather than Indian. So in a scenario like this, I think we will have to be a bit more careful. Nobody is talking about cybersecurity of AI. And I want to talk about two aspects from two different sides of the spectrum. One, that AI can be hacked, its cybersecurity can be hacked. We don't even think of it. We say, look, this is AI, whether it's Google's Gemini, whether it's OpenAI, whether it's ABC or XYZ, everybody is secure. Sorry. Read through the terms and conditions. They categorically tell you, please share information on a very careful basis. Do not share your personal information, confidential information. Why? Because there's a potentiality of these systems being hacked. So if you're using AI for justice, and as a hacker, I'm able to hack into that justice system, lo and behold, the kind of damage that I can cause is going to be phenomenal. On top of it, the second aspect of cybersecurity, using AI as a tool for breaching cybersecurity. So I come to know that judiciary of a country is using AI wonderfully well, and I want to derail it. What do? Number one, I breach the cybersecurity of that AI algorithm, and lo and behold, the entire system comes crawling down. Number two, I don't want to really dirty my hands. So I start using AI as a tool for breaching the cybersecurity of the other AI, which is being used by the judiciary of a country. So lo and behold, at the end of the day, what really gets hacked is AI. Who really hacks is AI. And the law enforcement agencies have no clue of who to capture, how to capture, and whom to actually attribute these activities. So I think as we go enthusiastically towards justice and AI, I want to sound a note of caution. I want to say, look at please the cybersecurity ramifications. Why? Go to the darknet today. Today afternoon, if I look at the broad, predominant feature on the darknet, it is cybercrime as a service powered by artificial intelligence. So we are all in the Zomato's age. We love to order, whether it's in the middle of night or anywhere. But now these guys have got you a new feature. You can order cybercrime. And then they give you an additional promise. You order cybercrime, we don't do the cybercrime, AI does the cybercrime. You are happy, we are happy, AI is happy. So lo and behold, we are actually going in a phenomenally different direction. On top of it, the legal liability aspects are completely not really being addressed. Look at the latest Illinois Supreme Court version. They say, look, the judge will be responsible for ensuring that the judgment is correct, whether he uses AI or not, which in any case the judge is going to be responsible. But if you are as a litigant and you're pinning your hopes, aspirations on a judgment that ultimately doesn't get written by the human judge, but by initially the first draft being the AI algorithm, maybe to a large extent those aspirations get dashed to the ground. So we will have to be mindful of those issues. We'll have to be mindful of the fact that in India, we don't have a dedicated law on artificial intelligence. I've been telling the government for the last many years, you'll need to have enabling legal frameworks. But in India, we love to only go on our past laurels. We believe the Information Technology Act 2000 is our mother legislation, will continuously be even applicable to AI. Well, if I was to look at AI only as a computer resource, yes, to a large extent, you may be correct. But the moment I go deeper, I realize that the nuances of AI are neither covered under the IT Act nor under the IT rules. We have a national policy on AI of 2018, but then that's only a mere policy. It doesn't really have any significant legal ramification. In this kind of a scenario, AI is coming at such rapid pace. On top of it, we now have a bigger problem. India doesn't have a cybersecurity law in place. So any breach in cybersecurity happens, I'm still going to piggy ride on section 66 and 43 of the Information Technology Act 2000 and the Bharatiya Nyaya Sahita 2023, most of which will be not very adequate. On top of it, I have to also realize the fact that we do not have legal frameworks to legally recognize the legal status or entity of AI. Is AI legal? Can I sue AI? Can AI sue me? Do I have rights against AI? Can AI have rights against me? Well, I'm arguing that humans' rights need to be protected in terms of digital rights, but there are some scholars which are saying, sorry, it's time to now look at the rights of AI, the rights of robots vis-a-vis humans. So when they took out this AI program in the International Space Station a couple of years back, this was called the AI Astronaut Companion. Its main job to be a companion for the astronaut. And it was opened up. The astronaut wanted it to play some music. It played its music. After 2-3 songs, the astronaut wanted the program to be quiet. So asked it to be quiet. The program warned the astronaut, you are being rude to me. Be careful how you talk to me. The program was shut down. The matter reported to the ground station. And lo and behold, that was the last we saw of this. AI going rogue is now the next big reality. We may not want to look at it, acknowledge it, but that's our problem. But if we are the proverbial pigeon who wants to close the eyes before the cat, then it's our problem, not that of the cat's problem at all. And while we are doing all this, I just want to pause here and tell you something that happened 17 months back. Well, we were busy in the so-called Josh and the favor and the wave of generative AI. In July 2023, OpenAI launched a small program. It's called the Superintelligence Alignment Project. It says, give us 4 years, and in the next 4 years, we will come up with a superintelligence which will be better than the cumulative intelligence of humanity as a whole. It's already now 1.5 years. And now OpenAI has launched version 03, which they say is a precursor of superintelligence. So we are still talking about just normal generative AI. And the superintelligence is already on the way of its development. So it's time to start looking at this entire issue from a holistic standpoint, cyber security standpoint, from the legality standpoint, from the privacy standpoint, and for the purposes of ultimately ensuring that whatever we do not ultimately emerge as an existential threat to humanity. So when Elon Musk is actually saying that AI is an existential threat to humanity, he's bang on target. It's only that we are so much busy in our lives that we are not seeing that we are now riding a running tiger. And unfortunately, we do not have the luxury to get off the tiger. We will have to keep on riding it. My question is, how do we go ahead and calibrate our strategies while we ride a running tiger? That will be $1 million question. Everybody will have to contribute, whether it's the the government in terms of new legal frameworks, whether it's in terms of judiciary, in terms of new approaches, whether it's in terms of users, in terms of ensuring that they do not share a lot of their information on AI, and whether it's in terms of protecting and preserving the cyber security of AI algorithms and also of AI data principles. And mind you, as I close, I just want to close with this final thought. The draft rules, Digital Personal Data Protection Rules 2025, are completely silent on how AI is going to go ahead and deal with this entire issue of data protection. It's only talking about data fiduciaries being responsible. So once I share my information, or once an AI algorithm gets my information as a litigant in a judicial matter, in a judicial proceedings, how it's going to use it, misuse it, abuse it, is anybody's question. I think we have so much of challenges at hand, but the quicker we start working on this, the better it is. Thank you, ladies and gentlemen.
Thank you, Dr. Pawan Nuggal. Very interesting points which you have raised, and particularly with AI and cyber security, synergy, which creates a lot of issues today, is an important point what needs to be looked at. Definitely, one thing I generally want to say, AI, is it a very, very generic thing, or it can be very specific, the way we want it to work, the way the knowledge it has to have, the database, the protection of the database and all that, can we have and can we create, is one thing which actually we should look at it, which I feel that technology has an answer and will have an answer, if not today, should have an answer and create it, is one thing. If you look at it, any technology, when it comes advancements, everything has a positive aspects and negative aspects of it always mingled with it. In fact, I keep looking at when the computers came, and actually there were questions in the minds of the people. Computers have come, what happens to jobs? Actually, I feel after a couple of years, after maybe 90s onwards, computers are the ones which have created lots of jobs, and that's how today every nook and corner computer science departments have come, so many colleges have come. And if you look at it, this country now, we are producing about 1.4 million engineers, and I feel primarily out of the software and computers related things which has created. The same, the moment software has come, it's immediately the viruses started and created and havoc and which has gone into it. And that is what actually we see the initial form of virus is seen as a cyber security product, and it has become as a cyber physical systems and all that, and which has become a big menace today. And now AI joined into it is another factor. But I also feel, somehow I felt, I may be wrong, please don't mind, some of the people at least felt AI is a competitor to us. Let us not have into that feeling of it, and we don't have to bring AI down because of that feelings. Actually, I feel AI is what we have created. We are always a human being, and we are here to create everything, and we know how to create it, and we need not be afraid of it. So we only need to see what we have created, what are the positive aspects of it, and what are the issues which are rising out of it, whatever the way. Whether it is we have not created the way we want it, or otherwise somebody else has infiltrated into it not to function the way it is supposed to function also. This is one of the important aspects what we need to see. I somehow very strongly feel when Mr. Roy was also telling is that when in this large population of 140 crores, when we have adequate expert doctors, if are not there, can't I have a medical aid from a properly designed, validated, verified, certified AI tool/machine? Can't it give an advice which is by and large, or I say that 90%, 99% of the time is correct, which is, as I said, properly validated and things like that. Not that the human being doctors are also not making mistakes. Probably the validation mechanisms, automatic mechanisms which can create and all that. That's why when General Mohanty was speaking also, I was thinking, today in the war also, he will agree with me, there are unwritten norms that today autonomous vehicles and weapons are actually as I said, as per the norm, illegal. And there may not be rule and people may not be following it and all that and things, but people started using it and all that because of all these issues only. You have an automatic weapon or autonomous weapon is an intelligent weapon. Whether it is actually, it goes onto the target or otherwise goes onto the human race is a question mark, and that's how as a civilian population will get affected or not is a question on that. So looking all those angles, can we actually, as Mr. Pavan Duggal was, Dr. Pavan Duggal was mentioning, and actually I also asked him also, can't we create frameworks? Can't we bring in regulations? Can't we bring in regulations right from the development side, utility side? When you are utilizing it also, probably in the judiciary we are utilizing AI tool. AI tool, when I say is, say A, B, C, D, 5 companies come and they give the tool and then I am using it without anything, and yes, as I said, a couple of them may give a wrong judgments and it is a judgment and all that. When I say it is properly developed with the inputs what Mr. Roy has given, that the local conditions, local emotions and local culture, everything built into it, can't we create a system which is a validated system? And on that system, can we have a overriding features and checking features for those judgments or whatever it is? Sort of a things can't we think of it? Because we also heard from all the speakers that AI is progressing very fast, and AI tools and they are entering into the life in multiple ways and all that, and we need to see. So how do we actually, the fast changing technology can be brought into it, it can be utilized in a proper way, and with the proper overrides and the proper things can be developed and all that we can see. So regulations and laws are very, very, very important. In fact, I've been working on personally on mechanisms, how this present cyber threats to a common man happening, how do we actually make it not to happen, or how do you protect a common man from these things, are many thought processes. I've held discussions with various people, experts in the country and all that and things like that. Unless, see, everywhere when technology comes, the laws have to come, regulations have to come. Actually, in fact, with the Nalsar, the law university, I am the first man who sat with a couple of professors and introduced the space law there, long back. So similarly, when we say cyber security or AI, whether you say regulations or laws, we need to bring in and mechanisms, certification mechanisms, processes, standards, all that. And yes, over and above that, what needs to be fed, what data need to be given. I fully agree with Dr. Pavan Duggal that in this digital world, in this world today, we have to be very cautious where, what we are giving and not giving. It's an important thing. It has been actually somewhere or other always data protection has been there centuries back also. It has always been maintaining many things, confidential, secrecy, information is always has been there, which is essential, which is much more essential. Once leaked here, it is a leak, and sort of a thing happens. So these also is important aspects, and those do's and do nots and all those things have to bring in, how to mechanisms to protect, and those processes which have to build into the society, right from village level to wherever it is, or people, very common man, to a coolie in a village, to very high level official or corporate people in the country, how to protect them, all that mechanisms have to be brought in. This is the need of the hour. But I very strongly feel that AI is become part of life. AI is a tool to facilitate faster things, quicker things to happen, and it is our duty and it is our responsibility how to make that is a robust AI is what we need to look at, and what robust mechanisms, regulations, laws need to be brought in. So with this, I thank all my eminent panel members who have given very, very, very innovative, thought-provoking ideas, thoughts, and mechanisms or questions posed to us and things like that and all that. I think we are all such may. I've been last 1 hour I'm thinking lots of thoughts are getting into our minds, and all of you I think agree that lots of thoughts would have gone into your mind also, how, what to need to do and all that. It becomes very essential. So with this particular in mind, we need to definitely appreciate Mr. S.K.Singhi for taking this initiative or Lexit, that in this environment, this becomes more and more online legal advice. I'm sure that it is not AI-based legal advice, AI legal advice. Definitely there are human beings and who will be giving the advice. You will not put a tool and then you answer between the two and all that is not the thing what is going to do. And definitely there will be people and things like that and all that, I'm very sure. So congratulations and best wishes, and I want this as a big movement to happen in the country to help all the people in the country in a very quick and faster things. And that is what it is. And thank you and all the best to you giving me opportunity. Jai Hind.
Thank you very much, and taking these learnings forward and building on the work that has already been done. And may the findings be beneficial for the entire humanity as we have been talking about it throughout the day. Ladies and gentlemen, before finally closing it, may I please invite Major General Rajendra Sachdevji, VSM, to kindly please present tokens of appreciation for our presenters in the beginning, and then I'll be inviting the other eminent dignitaries to join us. So Major General Rajendra Sachdev, VSM, to present a memento to the moderator first, Dr. G. Satish Reddy. Zordar taliyan हमारे moderator के लिए, Dr. G. Satish Reddy. Thank you very much for conducting this session and presenting your thoughts before all of us here today. Lieutenant General C.P. Mohanty. Lieutenant General C.P. Mohanty, thank you, sir, for sharing your thoughts with us today. Please join your hands, ladies and gentlemen, for each of our panelists as they share their thoughts with us. Thank you, Major General Rajendra Sachdevji. Thank you very much. May I please now invite Shri P.K. Goyalji to join us on the dais for presenting a memento to Shri Kazim Rizvi. A big thank you to all our panelists for sharing their thoughts with us today and for sharing those words of wisdom. We'll return back more informed than before. Thank you, Mr. Kazim Rizvi, for joining us on this panel. Thank you, Shri P.K. Goyalji. May I now invite Shri Prem Sibbal to present a memento to Shri Pradeep Raiji. Thank you to each of our speakers for joining us here. A big round of applause, ladies and gentlemen, for our speakers in this wonderful panel discussion that we just heard. A memento for Shri Pradeep Rai. Thank you very much, sir, for your sharings and for giving us your thoughts, perspectives, views, and ideas. जोरदार तालियां सभी की ओर से। Thank you, Shri Prem Sibbal ji. May I now invite Shri Srinivasan N, co-founder Petro Money Fintech, to present a memento to Dr. Pavan Duggal. A big round of applause for all our panelists. Post this, we will have a group picture followed by the closing remarks and vote of thanks. So we'll have a group picture now along with the entire panel. We request the presenters, the panelists, moderator, everyone to kindly please come forward for a picture perfect moment, remembering this momentous day. It is time to have a group picture, requesting Shri S.K.Singhi ji to also please join in. Thank you very much for that wonderful discussion that we just heard. Ladies and gentlemen, as we get set to close the day, in order to present the closing remarks, may I please invite Senior Partner S.K.Singhi and Partner Sri Akshay-Singhi ji to please join us. Please join hands and let's welcome Mr. Akshay-Singhi. May we please request everyone to give us about 5 to 7 more minutes. Post that, we all will meet at the tea break. In fact, we'll wind up with the high tea. May I please request everyone to give us 5 more minutes, please. Let us listen to Mr. Akshay-Singhi.
Good evening, distinguished guests, esteemed dignitaries, and dear participants. As we draw this transformative day to a close, I stand before you with immense gratitude and a sense of accomplishment. Today marks the culmination of months of efforts, vision, and collaboration that have led to the inception of Lexits, an initiative that represents hope, efficiency, and progress for the legal and business communities. Lexits is more than an initiative. It is a commitment to elevating the burdens of our judiciary, empowering litigants with predictive analysis, and bridging borders for a seamless confluence of Indian and international legal systems. It is an embodiment of the collective aspiration to make justice accessible, efficient, and timely, resonating with our ethos of social responsibility. Throughout the day, we have heard thought-provoking insights from some of the brightest minds in law, governance, and policy, from the potential of AI to reshape justice to aligning ESG principles with sustainable frameworks and exploring comparative legal perspectives. These discussions have not only inspired but also illuminated the path forward for a more inclusive and responsive legal system. I extend my heartfelt thanks to every speaker, panelist, and participant for enriching today's proceedings. And to our dedicated team at S.K.Singhi and Partners, thank you for turning this vision into a reality. Finally, I invite each of you to be active collaborators in this journey. Let us collectively ensure that Lexits evolves as a beacon of efficiency and inclusivity in the world of law. Thank you for being a part of this historic moment. I wish you all a pleasant evening. Thank you very much.
Thank you, Mr. Akshay-Singhi. And finally, to present the vote of thanks, may I please invite Ms. Akshaya Putran, Principal Associate of S.K.Singhi, Mumbai office, to please join us on the dais. The final vote of thanks.
Good evening, everyone. As we conclude this wonderful event, I would like to take this opportunity to express our heartfelt gratitude to all who have made this gathering possible. First and foremost, a sincere thanks to our eminent panelists and the speakers in the session who shared their valuable insight, experience, and thoughts. Your contribution have truly enriched, and we are grateful for your time and efforts. A special thanks to Lexits member of Board of Patrons, Advisory Board of Members, our host of the event, media, event management team, organizers, and also a special thanks to our Delhi team, Mr. Hargovind sir also, and the Kolkata team, and the Mumbai team, and the Bharat Mandapam, and their management, caterers, and each staff members therein, and the photographers whose hard work made this event run smoothly and successfully. I would like to thank our founder managing partner, Sir S.K.Singhi sir, our joint managing partner, Singhi sir, our senior partner, Singhi sir, for this providing us this much needed platform. Now, I would also like to thank Mrs. Urvashi Singhi Madam, Mrs. Preksha Singhi Madam, and Mrs. Pragna Singhi Madam for adding equal support for this Lexit launch. Now, last but not least, I would like to thank each one of you for your presence and your participation. It is your involvement that actually helped this event meaningful. Thank you so much, everyone. Have a great evening ahead. Thank you.
Thank you so much, Akshay, for that wonderful vote of thanks from your side. I think you covered everyone nearly. And as it was rightly mentioned that today is the culmination of months of efforts. Lexits is a commitment. It is a collective aspiration of making justice accessible to all. Ladies and gentlemen, with these golden birds, we would like to request you all to kindly join us for high tea. Thank you very much for joining us here. We hope that all of us will benefit from it. Let's proceed towards the high tea area, which is downstairs. Thank you very much.